principles of pro natura, all of the things that have to do with participation and access to justice. I would also think about principles that address these challenges of the new knowledge that comes through the traditional knowledge of our indigenous peoples, but that also reflects an acknowledgement of the crisis that we are dealing with, this global crisis. And so therefore the Constitution, it should really reflect, as a matter of principle, interdependence, dependence and interconnection and unity between human beings, nature, and biodiversity. I think that this concept of unity may allow for regulatory development and allow for jurisprudence and case law in complex cases. The legal tradition is very much rooted in evidence. The precautionary principle is assuredly a response to these very often these shortcomings rather in evidence with regard to this. So if we could find a principle that recognized this interconnected nature, perhaps a judge in analyzing a specific case could find a greater approximation to the world that is surrounds us with a long-term vision.
Que a veces son invisibles. Por ejemplo, la protección de la
addressing topics such as biodiversity. Chile has, of course, imported into its country a lot of things that are affecting our native biodiversity. But since biodiversity seems to be such a nebulous topic in terms of the law, it is very hard to get rulings in terms of these not only threats but this very real harm. So again, I think we need to use our classic principles, but some innovative ones as well. And I don't know whether this is a principle or an obligation of the state for the future, which is to cooperate more actively with the international community in the search for solutions. Just like in the past, there was a promotion of peace and human rights. Well, our governments need to commit internationally to finding collective solutions to these cross-border issues such as climate change. And for example, the Iguazu agreement, of course, well, there is certainly a topic there. Liliana, let me also take advantage of the opportunity to ask you a question that Mary Kay Lynch has asked, and that is, what is the controversy that exists with regard to the use of the word resource? And specifically in the case of the US, the word resource is important, for example, to address things like oil spills. I think that this is a classic controversy that has to do with not only the use of the word resource, but the idea of sustainable development, and specifically the question of what is development. And based on the discussion that we've had within the network, I can see that there is the word resource is associated with appropriation and things that are subject to appropriation or to ownership, like our mining concessions. So I think it's collective. I think there's some sort of intuition that development and the exploitation of natural resources has led to terrible consequences for people. And we can see what those mining concessions have generated, but there's been no distribution of the harm caused or of the benefits. So resources is immediately associated with property rights and specifically of exploitation per se. Constitutions also encourage culture. They create culture. And the Constitution of 1980, of course, in Chile, has really enshrined the concept of property rights and the ability to have these natural resources owned. So when we talk about the future model that we might have as of a state, well, the idea is to establish principles such as to ensure environmental equilibrium so that we don't have this issue of an extraction-oriented economy. And in Ecuador, in Bolivia, there have been very interesting approaches, but it's not really clear yet what the impact of that protection is. Does that actually protect what Ecuador and Bolivia have done actually protect the environment? Because this understanding of what of these rights and these right holders are, sure, we understand that it is a fundamental right to protection, but the actual impact of that recognition, of that acknowledgement, is not clear. And I think there's a concern that we may tend to go in that direction and forget others. And while it's true that what we have in the Constitution of Ecuador, but right next to it, there's our property rights, and those run against the rights of the indigenous peoples. So again, it's not really clear what that formula will be in effective terms. Thank you, Liliana. To conclude, I will give the floor to Professor Winter, who also wanted to refer to the question posed by Mary Kay Lynch. Professor Winter?
Está sin audio.
We can't hear you.
Ahora
I think
sí.
Liliana very well expressed concern about the use of the word resource, pointing to the fact that currently the word is used in the context of this is our property. Nature is our property. We can make use of it. We can manipulate it and so on. But this is, if we go back to the Latin origin of the word, is completely wrong. The word comes from the Latin word resurgere. This means to generate oneself again. So if one is used, one has the capability of regeneration. So this word can therefore only be applied to living resources rather than to fossil resources. And of course, it has this meaning, the traditional, the literal meaning, the Latin meaning, opened up new perspectives of protection, Liliana also mentioned. So we need to see to that living resources can exist once they are used. So they should be used only so that they can regenerate themselves. And that is the original meaning, and therefore I'm very much against the current use of resource to just express the possibility of disposal of property, of manipulation.
Okay, thank you very much,
you.
Professor Ginter. Ahora
Thank
vamos a...
you very much, Professor. We will, in light of time constraints, now conclude this presentation. It has been very interesting indeed. And now continuing with our schedule, we will begin in just a few more minutes with the next panel, which will be addressing the principles, the environmental principles. Thank you very much to all of our speakers once again. And thank you for your time and for joining us today. And thank you all to all who are following our feeds. We reiterate our gratitude to our speakers on this fourth panel of the forum. We are going to take a 20-minute break and we will come back at 12:25 Chile time. 12:25. We will see you at 12:20. Thank you.
Lo estamos transmitiendo, Roberto, ¿no?
Ya no estamos al aire.
Ah, ya. Oye, les agradezco las ponencias, realmente muy buenas. Muchas gracias, Liliana, muchas gracias, Jordi, muchas gracias, Henry, Daina. Y nada.
Y el profesor Ginter, que...
El profesor Winter, que ya sí, que lo que pasa es que no, se salió.
Se salió.
Sí.
No, gracias a ustedes.
Sí, muchas gracias.
Muchas gracias, muy interesante esta instancia, muy oportuna. Así que muchas gracias también y a los colegas.
Espero que les haya gustado, yo la disfruté
sí.
mucho.
Genial.
Seguro.
Sí. Tenemos más ideas y más confusión ahora.
Sí, pero estemos en comunicación.
Por
yo
favor.
de mi parte me gustaría escribirles y invitarles también para alguna actividad que vamos a tener en el futuro. Pienso que los temas son muy similares y los enfoques son todos muy importantes, de modo que vale la pena que sigamos remando en esa dirección. Les mando un gran abrazo desde este frío aquí en Heidelberg y les deseo muchísimo éxito. Gracias, Cristian, nuevamente.
Gracias, Henry. Muchas gracias.
Que estén muy bien.
Muchas gracias.
USC, Susan Borras, Professor of Environmental Law in Colombia, Susana Borras, Professor of Environmental Law at the Law School of Legal Sciences of Universidad Rovira y Virgili of Spain, as well as Peter Tobias Stoll, Professor of Public International Law in Germany. Our moderator will be the justice from the Environmental Court of Antofagasta. Justice, the floor is yours. Thank you very much, Angela. I am honored to moderate this fifth panel on environmental principles. And I must start by saying that since 2018 in Chile, we have a legal framework, some guidelines for the judiciary in a set of principles for sustainable development in the context of environmental law. This is a document drafted by the judiciary with the collaboration of the OAS, the Organization of American States, and the Ibero-American Legal Summit. And some of the principles included there are all of the legal principles that come from international law and in where the judiciaries and all those who have signed the protocol are encouraged to use these principles in the construction of environmental justice and environmental law in general, both the courts and the administration of the state in broader terms. Let me begin by presenting our first speaker, Professor Dinah Shelton. She is an attorney graduate of the University of California, Berkeley. She's focused on human rights. She's worked for the UN Environmental Program, the EU, the Council of Europe, and the Organization of American States. And in 2009, Dinah became the first person nominated by the United States to become a member of the Inter-American Human Rights Commission and chaired it. Dinah, you have 20 minutes available to you, and the floor is yours.
Thank you very much. It is a great pleasure to be here, the more so as during my tenure on the commission, I was not only rapporteur on the rights of indigenous peoples, but rapporteur for Chile. So thank you very much for the honor of this invitation. It's a thrill to be here. I was not able to visit Chile in person during the time I was rapporteur, so I'm glad to be here virtually and accept this invitation. I'm going to speak on environmental principles as they have evolved over the past 55 years. Beginning with the call for the first environmental conference by Swedish government in 1968. Several of my comments will refer back to other presentations. I don't know why I'm not being shown there on the speaker, but it doesn't matter. Okay, so the impact of the call for the Stockholm Conference had an immediate impact, among other things, in the United States, because shortly after the call for the Stockholm Conference, the first Earth Day was celebrated in 1970. And on that day, the state of Pennsylvania held a referendum to adopt in their state constitution a right to a safe and healthy environment as a constitutional principle. And that was adopted overwhelmingly and became the first of the constitutions in the United States. There are now more than 30 that have the right to an environment in the state constitution. The federal constitution has nothing, despite it being introduced every year since 1970 at the federal level. But the fact that all the state constitutions have it has given rise to a considerable jurisprudence based on the constitutional provisions, among them the state of Louisiana, the state of Montana, the state of Hawaii, and I could go on, but I won't for time's sake. So I'll start with the Stockholm Conference, where the first principles were enunciated in 1972 when the conference was held. The declaration had a number of preparatory meetings where various issues were debated, and a draft of 17 principles was proposed. Those were fairly controversial. There was a strong North-South debate and dispute at the conference that gave rise to a renegotiation, and 21 principles were retained, with 4 new ones being added and referred to the General Assembly. The declaration was adopted along with other final texts by the General Assembly. So there are 26 principles contained in the second part of the declaration. They can be grouped into themes, but several of them stand alone, and I'll focus on those that deal with environmental justice. Principle 1 in particular links human rights to environmental protection and refers to the most prominent human rights problems of 1972, condemning apartheid, colonialism, and racial discrimination. The principle reads, man has the fundamental right to freedom, equality, and adequate conditions of life in an environment of equality that permits a life of dignity and well-being. This convoluted syntax has given rise to several interpretations. At a minimum, Principle 1 restates existing international human rights guarantees of liberty, equality, and an adequate standard of living. The innovation lies in adding the exercise of these rights depends upon environmental conditions. And it seems to reflect an understanding that environmental degradation can impair the exercise of human rights. Read more broadly, Principle 1 initiated a widespread and ongoing movement to recognize the right to a safe and healthy environment as a new human right, something that was added to the constitutions of many countries throughout the world and to regional human rights treaties in Africa and the Americas. Many delegations thought that the declaration should begin with a general affirmation of every human being's right to a safe and wholesome environment. That was including the United States at the time. But others argued that it was implicit in the right to an adequate standard of living recognized in Article 25(1) of the Universal Declaration of Human Rights. Principles 2 to 7 constitute the heart of the declaration in setting forth the rationale for environmental protection and specific threats to the environment. They proclaim that the natural resources of the globe are not only oil and minerals, going back to the discussion at the end of the last panel, but also air, water, earth, plants, and animals, as well as representative samples of natural ecosystems. All of these should be preserved in the interest of present and future generations, bringing in the principle of intra and intergenerational equity. Renewable resources have to maintain their ability to replenish themselves, and non-renewable resources should not be wasted. The Declaration emphasizes the necessity of adequate resource management and the responsibility of mankind to protect wildlife and habitats. The section concludes by calling for a halt to the production of toxic waste and other matter that cannot be absorbed by the environment, and or a prevention of marine pollution. Principle 7 is the only principle in that group that contains the language of legal obligation, stating that states shall take all possible steps to prevent marine pollution, and could reflect the negotiations then concluding to in the London Dumping Convention. The last group of principles, 21 to 26, is of particular interest in the development of environmental law. Principle 21 is generally recognized today as expressing a basic norm of customary international law. It reads, states have, in accordance with the Charter of the United Nations and the principles of international law, the sovereign right to exploit their own resources pursuant to their own environmental policies, and the responsibility to ensure that activities within their jurisdiction or control do not cause damage to the environment or of other states or areas beyond the national jurisdiction. This, of course, has particular importance today in the context of climate change. The Declaration further affirms that states should cooperate to develop international law regarding liability and compensation for victims of pollution and other damage caused outside their boundaries, Principle 22. They should define criteria and norms in environmental matters, taking into consideration the system of values in each country, particularly developing countries. Finally, states should cooperate to protect and improve the environment and ensure that international organizations play a coordinated, effective, and dynamic role in this field. Of course, the Stockholm Declaration was not adopted as a treaty and is not legally binding as such. Most of the principles in there represent an agreed statement of environmental problems identified during the conference and the then current understanding of the causes of these problems, as well as a set of relevant economic and political considerations to be taken into account in resolving them. However, several principles do have normative impact and have had an important and lasting impact on the development of international environmental law. Several delegates referred to the text as the point of origin for the development of international environmental law. In the General Assembly, representatives referred to the Declaration as an acknowledgement of new principles of behavior and responsibility to govern interstate relations, and as providing an indispensable basis for the establishment and elaboration of new codes of international law. The conference report containing the Declaration was adopted on December 15th of 1972 with 112 votes and no opposition. Despite that, and because of that, and as an aftermath, several of the principles have emerged as legal norms. A large majority of the International Court of Justice declared in 1996 that the obligation of states to ensure that activities within their jurisdiction and environment respect the environment of other states, a reformulation of Principle 21, quote, is now part of the corpus of international law relating to the environment. The duty to cooperate contained in Principle 24 was called a fundamental principle of international law by the Law of the Sea Tribunal in its Provisional Measures Order of 2001. So the Stockholm Declaration provided agreed rationales for legal and political action on the problems identified. And following the Stockholm Conference, numerous initiatives were taken to conclude agreements and adopt national laws to identify the issues identified at Stockholm and the principles contained in the declaration. In particular, the UN Environment Program relied on the declaration and action plan in developing its agenda. It was based on a planetary conception of the environment and on a view of the institutional structures and world policies that was needed. It was also global in addressing all the major environmental issues of the time. And it was the major development in the evolution of environmental law until the Stockholm Conference. Up until then, most environmental law had taken a sectoral approach of first addressing inland waters, the environment, the atmosphere, outer space, wild plants and animals. And then in 1982, the General Assembly adopted the World Charter for Nature, which took a more holistic approach. And the negotiations for the Conference on the Law of the Sea resulted in UNCLOS in 1982 that has an entire part devoted entirely to the protection of the marine environment, and reaffirmed the global and regional regulations to combat marine environmental injury, including vessel source and land-based pollution, as well as pollution caused by dumping of waste and other matters. It also adopted significant new rules, in particular, the principles that states have a general obligation to protect and preserve the marine environment. During the 1980s, it became increasingly evident that a sectoral approach was insufficient to address environmental deterioration because it failed to regulate the causes or sources of harm that could affect one or more sectors. So a second approach, which aimed to regulate sources and risks of harm, became a common complement to sectoral regulation. The regulation of sources of environmental harm became much more common, and this eventually led to a common management of shared resources and an ecosystem approach. Finally, the global problems that emerged required comprehensive regional cooperation among all states, including climate change and loss of biodiversity. So new rules were included in instruments concerned with international law, including human rights instruments, humanitarian law, and economic law. In particular, the UN General Assembly proclaimed the responsibility of states for the preservation of nature in the interests of present and future generations. Later on, following Rio, we also got the UN Declaration on the Rights of Indigenous Peoples, which you heard about yesterday, and which includes an entire chapter devoted to indigenous environment. So in 1983, the General Assembly voted to create the Brundtland Commission, commonly referred to the World Commission on Environment and Development. The Brundtland report stressed the need for an integrated approach to environmental policies and projects, which, if environmentally sound, should lead to sustainable economic development in all countries. The report emphasized the need to give priority to anticipating and preventing problems. It defined sustainable development as development that meets present and future environmental and development objectives, and concluded that without equitable sharing of the costs and benefits of environmental protection, neither social justice nor sustainable development can be achieved. The Brundtland Report led to the convening of the second environmental conference known as UNCED, which took place in Rio in 1992, 20 years after Stockholm. There were 172 states that were represented, making it one of the largest conferences ever held. Some 116 heads of state and government attended. Stockholm Principle 22, which called on states to cooperate to develop international environmental law and policy, was advanced by the Brundtland Commission as a precursor to the Environmental Declaration at Rio, or the Rio Declaration. So the Rio Principles, it's a short statement of 27 principles. It has a composite and compromise character due to a complex legislative history. It reaffirms and seeks to build on the Stockholm Declaration, but its central concept is sustainable development as defined in the Brundtland Report. Principle 3 declares an unambiguous and unconditional right to development. Principle 4 says that environmental protection shall constitute an integral part of the environmental process or the development process and cannot be considered in isolation from it in order to achieve sustainable development. It retains an anthropocentric approach in stating that human beings are at the center of concern for sustainable development, and states that they are entitled to a healthy and productive life in harmony with nature. But there are in the Rio Declaration, as there were in Stockholm, several principles of an unambiguous legal character, reinforcing some existing principles and proclaiming new ones. The first category includes Principle 2 concerning the transboundary effects of activities. It repeats Principle 21 of the Stockholm Declaration. Other legal norms are found in Principle 10, affirming the public rights of information, participation, and remedies. Principle 13 calls for the development of liability rules, and Principles 18 and 19 require notifying other states about emergencies and projects that may affect their environment. The formulation of the then emerging principles, including the precautionary principle and polluter pays principle, has been followed by enormous developments in law, including also the general requirement and environmental impact assessment. The precautionary principle has been recognized by the European Court of Human Rights as binding law in Europe under the European Convention on Human Rights. The requirement of the environmental impact assessment is now recognized by the International Court of Justice, also as customary international law. The last group of principles concerns public participation. In addition to Principle 1 or 10 on the rights to information, participation in remedies, Principles 20 to 22 stress the importance of the participation of women, youth, and indigenous peoples in the protection of the environment and achieving sustainable development. So as I mentioned, the rights set forth in Principle 10 are also accepted now in national law and in international agreements. The principle of common but differentiated responsibilities is recognized in many international agreements. And as I said, the precautionary principle, while debated at Rio, it is now accepted generally and including within the European system as a binding principle of law. So the Rio Declaration established, reiterated a number of key principles from the Stockholm Declaration, incorporated others, and elaborated new principles with great practical impact. In the aftermath of Rio, virtually every major environmental convention concerning multilateral cooperation came to include environmental protection as one of the goals of its states. Principle 27 of Rio called on states to cooperate further in the development of the international law on sustainable development. A spike in the number of treaties after the conference demonstrates the impact of the meeting and its concluding texts. Sustainable development became the key organizing concept in all of these developments. So the UN Environment Program continued to reflect these ideas in its Montevideo program for the development and periodic review of environmental law. So in the aftermath of that, we saw the elaboration of UNDRIP, and then in 2002, the convening of the World Summit on Sustainable Development, which also provided concrete suggestions as to measures to implement the Rio Declaration. The plan mentions the principle of common but differentiated responsibilities and declares that poverty eradication, changing unsustainable patterns of production and consumption, and protecting and managing the natural resource base of economic and social development are overarching objectives of and essential requirements for sustainable development. So at the regional level, the Aarhus Convention was adopted in part as a consequence of Rio Principle 10 and has been very effective in hearing cases that have been brought when states have failed to live up to their obligations. With that, I will stop. Thank you very much.
Muchas gracias, Jaina. Bueno,
Thank you, Dinah. It is totally relevant, this perspective that Professor Shelton has offered us, and it serves as a foundation for the conversation that we're going to have during this panel on classical principles in international environmental law, together with those that are being constructed or drafted in the world we are sharing between the different states. I'd like to mention to our attendees that they can ask the questions on the forum's chat page. That's where the questions can be written, and then we will answer them at the end of the panel.
A continuación, corresponde presentar a la profesora Ángela Amaya. Vamos a leer acá mejor.
We will now be hearing Ángela Amaya. She's an attorney from the Externado Colombia University. She's a master in water rights from the Zaragoza University in Spain. She is a doctor of Law from the same university. Dr. Amaya is a professor, researcher, and consultant in environmental law and forestry rights for national and international organizations. She's also a member of the International Commission of Environmental Rights. Professor, you have the floor and you have 20 minutes. Good morning. Thank you very much for this invitation to be here today. It is also an honor to form part of this panel with such renowned experts such as Dinah Shelton and Peter Tobias and the Spanish professor. I would like to refer to a principle of environmental law that does not form part of the classical principles that we have seen in this presentation by Professor Dinah Shelton. But it does form part of the principles that are being used nowadays, even if we don't recognize the name at first glance. I'm going to share screen.
Si lo pusiera es modo
Creo que entonces voy a hacer algo que...
presentación.
Bueno. Ahí se
Ahí
ve
está
modo
perfecto.
presentación. Bueno, entonces yo voy a hablar acerca del principio
So I'm going to talk about the principle of no regression and how it applies today. Well, this has been mentioned before, but the crisis that we're experiencing may actually imply a reduction in the levels of protection and guarantees, both environmentally speaking, social and economic. This presentation, I started to prepare it in the beginning of the pandemic in March last year, and it's already been a year, and it would seem that the discussion continues to be very much valid. Here's an example that I use a lot, where the economic crises or crisis situations normally bring about less guarantees, less protection. And my doctoral thesis was carried out under Antonio Vipirujo, and Spain was starting to emerge from the crisis, and we were carrying out investigation on wind farms. But basically what happened was that the economic crisis and the social crisis they experienced implied a reduction to the incentives for wind energy. So at the end of these state subventions or benefits, it became expensive again, and it reverted to fossil fuels, and we reinvested in the energy matrix. So there was a greater use of fossil fuels again, with all the known consequences to the environment. And many of the studies in Spain were about how a crisis could imply a reduction in protection levels. How can it actually lead to taking away protections and guarantees? And at the case, the municipalities had to either pay for nurses and professors or subventions for wind energy. So at this point, the situation made them choose. And we started to see how crises begin to show this drop in guarantees. Now, yesterday, I refreshed this presentation and I found these articles from March 2020, both March 2020, and it talked about the positive environmental impact that the coronavirus has left, the planet, the benefits it has enjoyed because of the coronavirus, more water in Venice, wild animals recovering their territories or walking around in our streets. And I didn't find anything this year where this could be so noteworthy. What we saw in the beginning as a breather for the planet and the positive side of this situation, given the pandemic, was actually a moment in time, and then countries began their operations again, and we slowly returned to the original levels. Now, talking about regressions, and I just want to set a few examples before going into the concept. Entrepreneurs, when we have these news, the entrepreneurs in Colombia have found the need to reactivate the economy. They've asked the government to simplify these requirements, to reduce them, to reduce the demand and the paperwork in order to carry out economic activities and to reactivate the economy of the country. And they asked the president to back these express environmental licenses. These were meant to fulfill the requirements and the demands for technical requirements, that they be a little lower. And of course, normally environmental permits take a long time, and that stagnates economic activity. So since we were in a crisis, they basically wrote the government, the corporations wrote the government asking the government to reactivate the economy and to reduce the processes, or to expedite the environmental authorization processes. Our prosecutor's office also asked to reduce the prior consultations for by virtual media on ethnic peoples. We found a situation where it was not possible to do these in person in the middle of the Amazon. So we began to see how we could guarantee this right to consultations by virtual means. So connectivity in these areas, of course, is not the same. It's not, well, either null or very basic. So it wasn't possible to effectively or efficiently guarantee the protection of their right to participate in those areas. So the government had to make some decisions and said, okay, we're going to authorize virtual consultations. Many citizens organizations also helped, and they actually said that this virtual situation brings about limitation of rights, and communities and the community associations have said that they had not requested that this was just for a specific conversation, but they didn't really want this to be extended to all discussions carried out with the government and between the government and the communities. So this brings about a question: how do we address these situations to avoid this reduction in the levels of environmental protection that had been reached? How do we guarantee the protection of environmental rights in terms of the communities? How do we not reduce the protection standards with these express authorizations, environmental authorizations? And how do we strike a balance between managing a crisis of this scope and how do we still continue to maintain the guarantees? There was another piece in UN News that said no country shall shelter itself in COVID to revert its environmental policies. This is the no regression principle. It has other names in other countries, but it is an obligation, or actually the prohibition of going back on guarantees that have been established and protections that have been established unless they are duly justified. There have to be mechanisms in place for this. So the pandemic coronavirus should not be used as an excuse to reduce these gains. And after this announcement by the UN, several governments said that they would decrease their environmental laws. And in the light of COVID-19, it was said that these actions were irrational and that they were putting in danger the rights of vulnerable and non-vulnerable people. The principle of no regression is a principle that can contribute certain answers. It can offer us answers or strategies to manage this situation that we are experiencing. Where is its origin? It is in the Rio Plus 20 declaration, and it was expressly mentioned as a principle. And again, it was left as fundamental in order not to revert our commitments, to not turn back from them. It is the original doctrine on this. It has another origin, which is the principle of progressiveness. The principle of progressiveness that is part of the American Convention of Human Rights is a positive obligation where the states need to progressively increase the guarantee of rights. We all know this. The third generation rights, economic and cultural rights, are progressive because they involve an availability of resources. I cannot have perfect potable water availability immediately from one day to the other. It needs to be progressive. But in the same sense, I cannot revert this progressive advance. That is the origin of the explanation. So as I mentioned, this progressiveness and no regression are two sides of the same coin. So no regression is a minimum obligation by the state that is part of the prohibition of adopting measures and policies and consequently of enacting laws that could worsen the situation of the population at the time of the when the international treaty was adopted, but it is not necessarily just about that. Given that the state takes on the obligation to improve the situation of these rights, there is a prohibition to reduce the levels of protection of the laws in force or the rights in force. So the Colombian jurisprudence after Rio Plus 20 already had some of these principles included in the. We have a 2009 sentence that expressed this, and we also have the case of Argentina from 2002. But in Colombia, this division of rights, first generation, second generation, and other kinds of rights, is an academic division. And there is, all rights actually have a phase where the state needs to do something, needs to provide something at a greater or lesser extent. With the first generation rights differ from others. The Constitutional Court says that all rights have their as essential rights. Excuse me, she is speaking at the speed of light or reading at the speed of light. It says that the collective nature of having a healthy environment does not exclude others. The right to a healthy environment may have this existential nature, and we are somehow tied, our hands are somehow tied with this, but the development of the topic has actually shown a way to make this principle operational in reality. In Argentina, it needs to be gradual. That's what they say. The environmental objectives must be achieved gradually by means of internal rules and laws, and also applying the no regression principle. And in France, they have the principle of no regression, through which the protection of the environment is guaranteed by legislative provisions, and of course, taking into account scientific and technical information. And in Peru, I don't know what city it was, on September 6th, it said that the Constitutional Court has recognized the right to the environment in urban planning, and the local governments must respect the minimum standard of green areas in cities. Here we can conclude that from one area to the other, an area turns into an area of protection or of non-protection, of a mixed protection. And it's relevant. On one hand, we see the principle of no regression. We're not mentioning it here. And one of the origins of this principle is the standstill principle. This Belgian principle, which is also mentioned, is specifically for the urban areas, green urban areas. These are minimum no return areas. They're not affectable. And this is very strict for planners or for municipalities. This standstill or no return principle says that there are areas where there is a greater protection, and any modification made on these areas will have to be highly justified. The motivation must be qualified. Many more studies must be presented, and so we need to once you have these urban areas, green urban areas, you can't really modify them for just any reason. You need to find very specific justifications. With this example, I will conclude that part. This principle was incorporated into Escazú, the Escazú Agreement. It's Article 3. Principles, each party will be guided by the following principles. There's no definition, but basically you are familiarized with the Global Pact for the Environment. This is a French pact that seeks to establish a series of principles, and the philosophy behind it is that principles due to soft law principles and non-binding principles seek to find an agreement for the mandatory nature of this no regression principle. So the parties and subnational entities will abstain from allowing activities or adopting laws that could in any way reduce the level of environmental protection, worldwide environmental protection that is guaranteed by the law in force. So when you read this definition without the asterisk, if you read it to corporations, they are afraid because basically what they feel is there's no freedom for their activities. I'm going to conclude in a moment, but basically, and in conclusion, the principle of no regression has the following premises. One, a reduction of the level of environmental protection that has been reached without a justification or motivation that must be justified. Specifically, there is an obligation from the state that must protect this measure. When I mention the example, this will be much clearer. It does not mean that the standards will become extremely rigid. On the contrary, it seeks to generate flexibility regarding environmental law in order to respond to these new challenges and contexts. The principle of no regression offers general rules to address specific situations. It may be contradictory, but these rules allow us to move in the specific case. And it's not really the same as the prior consultations. There are strategies that allow us to move amongst these and find the best solution for a specific case. It also allows for an analysis that will contribute innovative and different answers to current challenges without reducing constitutional guarantees. For this, we need to go a little behind the theory of the principle, and I created this regression test. It basically helps us analyze the proportionality, how reasonable it is, and it allows for an autonomous judgment. First, we have an analysis of the measure that contains the environmental protection level that has been reached. Basically, I look and see what norm is actually generating that impact. And second, I analyze the actual measure, formal or material, that reduces the level of environmental protection that has been reached. And third, you need to analyze the justification, the end, and the proportionality and the need for it, for this regressive measure. And the inadmissibility or admissibility of this regression measure should not pass the test. In this case, it fully exceeds this regressiveness. They are measures that, although regressive, are admitted by the law. There is a higher motivation, a higher justification that allows for this motivation. So the definition is a restriction to public powers, not only the legislative, but also political operators and judges, to reduce or affect in any significant way the level of environmental protection reached unless it is absolutely and duly justified. This is about an implicit principle that we believe is formulated very subtly, relative, because each specific case has a different judgment, and legally binding because it has its foundations in the principle of no regression, and with constitutional and legal foundations that are increasingly solid and whose limits must be determined on a case-by-case basis. Consequently, the measure will be understood as regressive when it reduces or significantly affects the level of environmental protection reached, unless it is duly justified. This is constantly changing. It is not single provision. I know my time is up. It's 20 minutes. I would like to take 1 or 2 additional minutes to just conclude with the example. This case is noteworthy. It doesn't specifically mention the no regression principle. This is a case from 2012 in Spain, and they wanted to modify the urban planning. So the municipality wanted to change the use of soil to, or the land use, in order to build a library in a green urban area. So basically, they had the discretion to change this use of land, so it wasn't illegal. But what happened was that the Supreme Court, after having made the modification, they sued. There was a lawsuit, and the Supreme Court said, or ruled, that the standstill principle, or the principle of no regression, would protect these green areas. So it required a full analysis of the measure. And again, the green areas, as I said, are no return areas. So what is the first step of the analysis of the principle of no regression? It is the initial measure of the town hall, which requested the change of the use of land to build this library. But how is it authorized? The planner did this legally with adequate argumentation. So they decided to affect a part of the green urban area to build a library. Is it valid? Yes. I am not doing anything illegal. I am building a library, which also represents a legal activity.
So thirdly, there is an impact. And this is when the court said that there had been no indication that the library could only build there. And that is because there had been other aspects in the city, and it's not because it was needed, because it was not proportional, because it was appropriate to build it in this particular park. We go back to the principle of non-regression. We can see how the regulations give us the response. The traditional regulations say, yes, City Hall, you can use the soil as you wish, but the value that society gives to its park area means that even though the regulations are valid and the actions are valid, then these principles begin to give different answers in concrete cases. Now, this transformation of law through the principle of non-regression is a principle or an example of how this principle has enabled us to find different innovative solutions to the crises that we are experiencing today. For example, in the case of the impact on Indigenous rights, if we continue to look at this in the same silo that we've always used, then the principles will not be useful. But if we begin to use other disciplines, such as design and legal innovation, the use of technology, in keeping with constitutional rights, then we will be able to transform the law and legality to continue with this evolution of the principles of environmental law so that they in fact can help us solve the crises that we are experiencing on our planet today. I'm sorry I ran 4 minutes over. Thank you very much. I will stop sharing my screen. And on that note, again, I will conclude. Thank you, Angela. That is a very fast-paced but clear presentation that enables the judges to look at other options. As you quite rightly said, there is perhaps sometimes an erroneous belief that the principles support the legal structure, and people fail to see that they can serve as an escape valve when there are legal constraints that are forcing a situation that is patently unjust. So this reasoning that you mentioned, this reasonability criteria that you've referred to, and the test of proportionality, need, and so forth, if these can be attained in the specific case for the administration, for a judge, being able to do an objective analysis of pertinence is important. And it is excellent work. So congratulations, Angela, for this outstanding presentation and tremendous food for thought. Let me now turn to our next speaker. We will now hear from, well, let's see if Susana is here. There she is. Now I see her. Professor Susana Borràs. Am I pronouncing that correctly? Borràs? Yes, with the accent on the A. She is an attorney at law, master in environmental law, PhD in European law, and has also been awarded outstanding researcher awards by her university on mitigation, local government, and environmental law, the Center of Environmental Law at Universidad Rovira y Virgili in Barcelona. You have the floor, 20 minutes, Professor. Thank you very much. I would like to share my screen. I trust that you will be able to see that. If you could perhaps put it in presentation mode. Perfect. Very well. Good morning or good afternoon. I am pleased to be able to participate in this 4th International Forum on Environmental Law. It is a privilege and an honor, and I am thrilled to be able to join the other speakers on this panel for such timely thoughts. My contribution here will be less legal or practical in nature and more theoretical in nature. Take a moment to think, to reflect is also important, and it is a good time for us to do this at this juncture, I believe. I would like to thank, of course, Cristian del Piano for the invitation and the Second Environmental Court as well for this opportunity to be remotely in Chile. I wanted to begin by recognizing that there is an illness on the planet today, not just the pandemic, but the current crisis, which is multi-dimensional. Climate change, environmental, social, energy, poverty, economic crisis, crisis of law. All of these are symptoms of a very severe illness that affects the planet, but that stems from our system. In fact, we shouldn't be talking about the pandemic, but the most important, or a better word would be syndemic. This is, as we've seen, as Paul Crutzen, Professor Crutzen, Nobel laureate in chemistry, recognized that for the first time in history of the planet, we have seen how human beings have been able to modify how Earth operates. Again, a few million years ago, human beings were just a moment, just a blip on our screen. And yet, as human beings, we represent 0.1% of the life present on the planet, and yet our impact is extraordinarily disproportional. And despite our significance on the globe, we've altered it significantly. Now, of course, not all of us have done so to the same extent, and not all have had the same impact. At this time where we're seeing this eco-social collapse, we can see how this has become much more severe. It is not in vain that Bana Shiva has talked about how we are experiencing these different symptoms of this illness, the extinction of biodiversity, among other symptoms. We're seeing what we called the seventh elimination. According to the IVth ecosystem assessment, we can see over 1 million species are in dangers, including, and we've seen a very large number that have already become extinct. The pandemic, of course, has been extremely harmful, but it's also shown us the eco-social crisis, and that is giving us an expansive system as well that involves a dynamic that reduces the space available to living beings, and we've sought to eliminate, nonetheless, a number of biological entities, and we've seen efforts to combat microbes for many years, and this clearly has had an impact on life on our planet. We are now at the verge of the planetary boundaries. Professors Rockstrom and Richardson in 2009 discussed these planetary boundaries and said which ones we simply cannot cross. And if we did so, we would end up in a type of uncertainty in which our life as humans would be compromised. Recognizing these boundaries also helps us to better understand that deaths and viruses are not happenstance. The pandemic, of course, has been the result of this so-called civilizing effort, and the research by Rockstern and others again in 2009 told us that we had planetary boundaries, which we identified in loss of biodiversity and nitrogen and climate change were already beyond the uncertainty threshold and severe risk. And in 2015, a new version of this study added two more. That's the phosphorus cycle and the change in the use of soil. That is to say that we have 5 of the 9 boundaries that are at the dangerous level to, again, endangering the survival of the human race. Now, these scientific research and these boundaries, as you know, of course, are not novel. It's been some 50 years now since in 1962, a publication was made at MIT that referred to the danger of overcoming or surpassing the biophysical capacities of the planet. And yet we did not see environmental policies and so forth to contain this growth. And we, despite certain efforts, we are nonetheless on the brink of collapse. In fact, we've also, in this healthcare crisis, have tended to ignore the emerging and the present climate emergency. We have greenhouse gases that are, of course, responsible for climate change that are now being ignored, despite the fact that we have reduced our growth and our emissions during the pandemic. We are nonetheless suffering. It has not reduced climate change at all. Now, if we look at the special report from 2019, with regard to seeking to restrict climate change and global warming to 1.5 degrees centigrade, we've seen that there is a scenario that if we do not take appropriate measures to grapple with this other crisis, one of global warming, in addition to the health crisis, we, by 2050, again, according to the IPCC specialists, we will see global warming at about 4.5 degrees centigrade. Therefore, the lack of effective progress is tremendous, along with the loss of biodiversity. These are undoubtedly the biggest challenges that we are confronting today to ensure life, not just human life, but life on the planet as we know it. The Worldwide Fund and others in Australia have made it clear how this loss of biodiversity is generating very profound changes in ecosystems that compromise life of ecosystems and of millions of human beings. Well, what does this have to do with the principles of environmental law? I would like to thank Professor Shelton for all of the historic overview that she has given us, because it is very clear how these principles have evolved. Despite the fact that these tools are available, it is clear that we've nonetheless been unable to prevent the collapse of ecosystems. The principles of environmental law are important and are key to allowing for respect and have predated regulations. Therefore, these principles are the primary tools that enable us to move toward better tools to grapple with the current emergencies. The principles reflect consensus built by the international community, despite the fact that the international community and states have tremendous environmental, social, economic, and political disparities. Nonetheless, the principles of international or environmental law have nonetheless played a key role that goes beyond the principles enshrined in other fields of law. And Professor Shelton has noted this clearly. The Declaration of Rio, the principles of emanating out of Stockholm, and so forth, suggest that their broader acceptance, their recognition in domestic law, and the fact that they have been enshrined in international treaties have led us to understand that many of them autonomously have come to supplement Harborough principles, and some of them are now considered to be jus cogens. So they are multifunctional, heuristic, and so forth. But in any case, as I said previously, despite these advantages in the scientific and the legal perspective within the context of environmental law, there are certain limitations. Again, and that is that collapse has not been avoided. Now, one of the shortcomings is that these principles are dependent on substantive law. Another shortcoming into these principles is that they are primarily anthropocentric, where people are at the heart of sustainable development, and life is limited in its recognition by law to human life. But the recognition is that we are living in the era of the consequences of all of these forms of collapse. We are eco-dependent beings, and we can see that this eco-social collapse, the era of consequences, as Granton has said, of living in the Anthropocene, means that we must take, of course, urgent action. It also requires that we understand that we must create new ways of interacting between and among the forms of life on the planet. The relationship between human beings and nature historically has been one of use and abuse, and environmental law and the principles of environmental law have been unable to avoid that. Therefore, we need a new concilium to protect life on planet Earth, not just human life. Therefore, there is a needed response. It's just like we saw in the 1970s, there's the ecologic movement in the 1970s that emerged in an effort to build a system that is capable of responding to these environmental challenges. Just as that movement emerged, we need an opportunity or way of going and looking at the traditional law, that anthropocentric approach, to a vision that will enable us to focus on life. And therefore, as a social process, we all need to engage in this process. The principles, despite their limitations, I believe are the necessary means, the necessary vehicle that will enable us to transit toward an eco-civilization that will move from the Anthropocene to our Ecocene, based on what Leonardo Leboeuf has said. The use of the system has led to a hegemonic approach, not only to nature, but also to human beings. And not only just of human beings, but also human populations that are most impoverished and most disenfranchised as a result of the hegemonic powers that have led to a dominant and domineering approach to nature. We therefore need decolonialization, not just of politics, but also the environment. The law, from the anthropocentric perspective, is not sufficient to protect human life or natural life, and particularly the life that really needs additional protection. Therefore, we need a moment of inflection, of thought, to be able to reflect on these global issues and how these problems are looking at the biosphere, and which is very much alarming in terms of change. And all of these problems, therefore, are not just pandemic, but syndemic and systemic, that must be analyzed in an interconnected and interdependent fashion.
Therefore, this should take us to making environmental law more ecological, and we should call it the principle of ecocene, the ecocene, not the Anthropocene. And it must be done in dubio pro natura with the no regression principle. It must be based on two premises, two pillars. One is the affirmation that all living beings have the right to enjoy their development as such and to live their lives. And the second pillar is that every life form is interdependent and needs physical support. So this is the fundamental right that we find in the nature chart, where life is the main support of this transit into the ecocene principle. What are the principles of the ecocene in this legal order that must make environmental law more ecological? Some are found in the International Charter of the Environment from 1982. Others are indirectly found in the Rio Declaration. Others were finally developed by the declaration of the ICM that was agreed at the global conference in Rio de Janeiro in 2006. And some have been the result or have had a greater impact at an international level, but also in internal legislative laws, as Professor Amaya mentioned, the principle of no regression, the principle of progression, and the protection of the environment, as well as the indubio, the intergenerational protection, the indubio pro natura, which means that all processes need to be resolved in a way that will favor the conservation of the environment, offering preference to the alternatives that are less deleterious to the environment. So it is the prohibition of any action that could imply a reduction of the protection of the environment or access to environmental justice. The principle of progression, which together with the no regression principle are both found in the Escazú Agreement. But this one is also included in the Paris Agreement. It's necessary that the obligation to review and periodically improve these laws and regulations in order to restore and improve the environment, and the intergenerational principle also linked to the interspecies. It is this intergenerational and interspecies legislation that is going to be in favor of these lives. All these principles materialize this right based on ecological means that do not want to replace the traditional environmental means, but to reinforce them, to facilitate the transition of this exclusive anthropocentric transition, and to include a less restrictive perception of the concept of rights. The idea is to expand this concept of rights to include other non-human species. That is what we mean by ecological justice in the three dimensions: spatial, the regional, national, and planetary level, the intergenerational and intragenerational dimension, and the biocentric dimension, which includes the intra and interspecies. That is why I chose these 5 principles of all the others that have been mentioned and developed as of Rio 92 and Rio +20, because I believe they stress this vision, this change towards an ecological or environmental justice that guarantees the dignity and integrity of all forms of life and the survival of human species. So it is a planetary effort based on this ecological justice, and the main axis must be the principle of ecologic sustainability and not just sustainable development and resilience in order to achieve the protection and reestablishment of the integrity of all ecosystems, as well as maintaining and continuing with the resilience of all these systems in order not to exceed these planetary limits that we were referring to. So it is a matter of adaptation to this eco-social crisis. It's resilience and advancement of what we already have in our current reality, but it's also about responsibility. And these principles have not only been developed as part of this global impact for the environment, but also the doctrine. This path of this development of these principles has already begun. And in traditional law that as has been developed, we've seen this with this conciliation of biocentrism, which was presented before by Ecuador, Bolivia, other Latin American countries, which allow transforming classic environmental law by lightening up this anthropocentric perspective and including the new elements of biocentrism. Again, we do not wish to replace one with the other. We do not want to quit or renounce what has been done these past years. We want to have a progression of life so that it can be guaranteed. On the other hand, if we were to say that environmental law with this anthropocentric perspective could have been defended by means of the application of the principle of a right and of future generations, well, it's not like that now. The way things are today with the eco-social crisis, we cannot guarantee the right of new generations to enjoy a healthy environment. So the anthropocentric perspective of a human right cannot really be projected into the future. So we need our elements or different elements that will allow us to guarantee this systemic perspective in order to guarantee the anthropocentric perspective. So we have these political and economic things that enable the effort and bring environmental law together with other branches of law, commercial, civil, etc. So all these tools that have been used for other players, why perhaps we should use it to recognize rights that are broader than what we have conceived anthropogenically in order to guarantee our own human rights. I would like to conclude by stressing the principle that represents, that I feel is most important. And the principle of no regression and the principle of progression and of this commitment to nature and the need to respect this legacy for coming generations, future generations. That is the indubio pro natura principle. And this principle has been broadly presented in jurisprudence in Latin American countries, Venezuela, Dominican Republic, Costa Rica, Ecuador, even Chile, and directly has done it by recognizing indubio pro ambiente. And it includes this need, this principle that began linked to other precautionary measures in Venezuela, Costa Rica, Dominican Republic, has progressively evolved to the point it has a substantive character, and Costa Rica it's used to interpret the conflict, any conflicts that may arise, and those laws that are favorable to nature. So this is a principle that should be applied in jurisprudential seats, and as in the case of Ecuador or Costa Rica, subsequently, it would have expanded as a hermeneutical principle for conflict resolution between environmental laws, but also as a principle that should inspire the need to bring it to the political and administrative realm. It's not easy. It's been subject to a lot of issues, many conflicts, but the situation shows an increasing need to follow this line of improving environmental law, of anthropocentrism, of having an environmental law that is more ecological, that better responds to environmental justice, but also ecological justice. It must also answer the need to include human rights should there be an eco-social collapse. It's important to include this regressive situation together with environmental protection. And with this perception of leaving a legacy to future generations, if we continue the way we are going, the Earth will degenerate. Eventually it would recover, but the human species as we know it will probably be extinguished. I will conclude with this third point, which is that the relevance of the indubio pro natura principle, as in the case of the other principles that we've mentioned, are ex novo, and they should be applied with this judicial principles that we have seen that are being included in Latin America. They are hermeneutical principles that would also have to be applied to decision-making. So with this last reflection, I will conclude my presentation. Once again, thank you very much for the invitation to participate in this 4th International Forum on Environmental Law. Thank you.
Thank you very much, Susana. Very interesting and thought-provoking presentation for those countries that are moving through a process of rewriting our constitutions. What you have suggested is certainly, again, food for thought in that process. And noting how, particularly that the principles have not led to, or not stood as an impediment to deteriorating environmental conditions. And perhaps we can think about more intensive application of them in the future. That leads us to a question for the panel that was posed in the previous session about the future of the panel. Excuse me, the future of the planet. The interpreter apologizes for the drilling noise in the background. Unfortunately, there is nothing she can do about it. Let me now turn to Peter Tobias Stoll. You will have the floor in just a moment, but I believe there's a tall task before you, as the presentations that we have heard have been tremendous and extraordinary. So no pressure, my dear friend Peter. Professor Stoll is a professor of law. He is the director of the Institute for International Law and European Law. His areas of research are EU law and interfaces between economic law, trade, investment and trade, environmental protection, and consumers. He's also participated in a number of negotiations at the international level on behalf of the German government, including the Ministry of Foreign Affairs, Ministry of Agriculture, and the Ministry of the Environment. Without further ado, Professor Stoll, you have the floor. You have 20 minutes. Thank you.
Chair Mauricio, thank you very much for this and for the kind introduction. Members of the panel, ladies and gentlemen, thanks to the generosity of the president of this court, which is Christian Del Piano, a good colleague and friend, some years ago I had the opportunity to participate in the opening ceremony of the first environmental court in Antofagasta. I consider the establishment of environmental courts an important achievement, and I hope my country will follow suit sometime. I'm not very optimistic about that. It is even more impressive to see that this court also engages as a forum for discussion on environmental law, and I'm really fascinated from this richness of thought in principles, in constitutional developments that I had the honor to part in. Such reflection, I think, is necessary in a young and quickly developing field of law. Thank you very much for the honor to be invited to participate in this endeavor. Today, I will try to explain to you the EU's Green Deal that might be far away from Santiago, but I do so nevertheless for two reasons. First of all, some small information might be welcome, but secondly, I would like to use that development as a starting point to reflect on the principle of sustainable development and what we as lawyers could do about it. And with this, I try to share my screen. Hope it works. And I added a subtitle which is Exploring Potentials, Task for Legal Reflection, in order to tell you that this is a work in progress, and it's actually required to me because I have a Jean Monnet chair, especially on sustainable development, and I work in this area. And I would like to share some of my observations and questions with you. I consider the principle of sustainable development to be one of the most impressive innovations in international relations and law. Let me say this, and I'm happy that Dinah referred to us and explained us so ably the developments and the content of the Rio Declaration. It is not only that it married, in a way, environmental and developmental policies. It is also so because this idea of sustainable development had implications for international, for regional and national levels. It has had also, of course, a very strong political outcome. So basically the SDGs, which in a way concretized and translated sustainable development in objectives, in goals that you could measure, and that was certainly another very big improvement. The principle of sustainable development also had a very huge legal impact. It has not only been incorporated into numerous international agreements and national and regional legislation, but it also has been frequently referred to by courts. And Dinah has already explained that in some regard, it could also be considered to be customary international law right now. And I should say, in a way, we as international, regional, or national environmental lawyers have been very much charged in recent times with bringing this about, in trying to help to translate the principle into legislation or international agreements, and to help to bring it to bearing in courts and tribunals. And this has been that has been a great effort and a great achievement. But I wonder a little bit whether we could go more far in a way in unfolding the principle. Now that we have achieved kind of legal acknowledgement of the principle, I wonder if we as environmental lawyers could not do much more in fully bringing it to its potential. And I will tell you in a minute why this is very much important. I think it is very much important when I look to what I know a little bit more about, which is this huge project going on in the European Union, which has the name EU Green Deal. As you know, this project has been set up by the new EU Commission under Commissioner Ursula von der Leyen, and she really made, in a way, kind of a political program which would cover, in a way, all EU policies, and which basically is not only understood to be green in the sense of environmental protection, but it's also deeply informed in a way by our ideas of sustainable development, and particularly by the Sustainable Development Goals. And it explicitly refers to the Sustainable Development Goals in stating that the Green Deal is considered to be the EU's implementation of those SDGs. And if you read the basic document, there's a quotation saying that the Green Deal is a set of deeply transformative policies. And really, in Brussels and in the whole EU, there are very high expectations because, can you hear me? Hoppala. Okay.
The interpreter can hear you.
Okay, because I got a sign that I couldn't be heard. Okay, thank you so much. Can you hear me, anybody?
Yes, we can hear
Okay,
you.
thank you. I'm very sorry for that. Just in brief, to explain to you the EU Green Deal, and I will put a graph from the EU Commission on my next slide. Basically, it is about, it covers a number of well-known environmental policies of the European Union. But it's not only that. It's not only that the goals are very ambitious. It is also a very close kind of a integration between environmental policies and the economy. And I briefly refer only to the sector of energy, mobility, and sustainable finance, which I think is a very good idea. But what is rather new about it, because so far the European Union was basically considering sustainable development something for environmental policies and for international relations and for international development cooperation. But now the European Union in a way acknowledges that really implementing sustainable development would also need a kind of a social pillar. So this social and societal dimension of sustainable development is in a way well addressed, and there is often mentioning of the word "no one left behind." And you know this from kind of US and United Nations papers and documents, this word for, which is basically about social justice and social rights. So for instance, it envisages a just transition mechanism, which is basically funding for those parts of industry, but also of society at large in the context of the implementation of the whole Green Deal. And there's also something called the Sustainable Europe Investment Plan. Altogether, there's a very nice graph in this basic paper, which explains to you the various issue areas of this Green Deal. So it includes a lot about climate change, energy policy, circular economy, building and renovation. There is a shift to sustainable and smart mobility. The farm to fork part of the paper is very much about reforming EU agricultural policies. There is, of course, something on ecosystems and biodiversity and something on zero pollution for toxic-free environment. Altogether, it has this very funny kind of understanding that the European Union would be a global leader. I think that is rather selfish if we look to other regions. For instance, if we look to your regions with the many important and fascinating developments, then I would like it to have a smaller coin, but nevertheless. Also, it's about research and innovation, so it's good for European universities in a way. I'm joking, but it's rather interesting because at the same time, a agency of the European Union, which is Eurostat, which is the statistical agency for the European Union, tried to develop kind of a mechanism to calculate the progress of the European Union in the area of the Sustainable Development Goals. And you can see here, I'm sorry if you can't really read the graph in all details, but you can see that there's actually a development in Brussels to make visual the kind of progress that the European Union is doing in terms of the SDGs. And you see, we have, we have very much progress in the area of peace and justice, but we have very poor progress in non-discrimination. And you see all the different kind of environmental and other issues are in between somehow. But I'm not after the details of this graph, but I would like to explain to you that if we look at this whole development of the Green Deal altogether, we would find that it is basically a governmental program, and that has quite some tradition in the European Union. And of course, the Green Deal documents as such would not have any kind of a direct legal effect. And I'm sorry that Geert Winter is not in this session because he was lately discussing the question whether there could be an indirect legal effect of kind of governmental programs and decisions. But nevertheless, it is, of course, a master plan for legislation to come. There are lots of legislative projects in the Green Deal, so we can watch out what will come later. But my point is that there is not much kind of a legal context. So sustainable development in the lens of the Green Deal is understood as kind of a huge technocratic, bureaucratic endeavor, which is certainly in a way laudable and which is also quite impressive. But the question remains, isn't there something to do for the lawyers? You could even believe that either sustainable development is fully implemented when with the Green Deal, if you read all the prosa in the basic documents, or you could believe that sustainable development turned into something which is in the hands of governments and is treated by their normal kind of technocrat work, which is certainly laudable and important, but of course is not the whole story. And when I came to this point in looking at the Green Deal, I thought, what should lawyers do about it? We have this wonderful principle of sustainable development, which goes back to the Rio Declaration. And as Dinah rightly explained, basically has been mentioned the first time in the Brundtland report. And we are very happy to see the Sustainable Development Principle to be, in a way, incorporated in hard international, regional, and national law. But I think that is not the end of the story. what we possibly have to do is something what our colleagues from human rights always call the mainstreaming. That would say it's not enough to establish normativity for a principle or for a rather generally framed right, but you would also need, in a way, to contextualize it in the context of other legal provisions and mechanisms at hand. And that is, I call it contextualization, but I'm also happy to use the word mainstreaming. But that is certainly something which is lacking with this Green Deal project. And if you consider all those provisions which we have in EU law, which are not cited in this papers on the Green Deal, there's already kind of enough starting points for doing so. We have, for instance, the idea that sustainable development is a basic principle not only for the economic policy of the European Union, but certainly it's also the basic principle for environmental policies of the European Union. And even more, in our, as you might know, the European Union got, with the Lisbon Agreement, got something like a Bill of Rights. And there we have in Article 37, which actually states a high level of environmental protection and the improvement of the quality of the environment must be integrated into the policies of the Union and ensured in accordance with the principle of sustainable development. That is really fascinating because the Charter of Fundamental Rights of the European Union is considered to be a Bill of Rights, basically. Nevertheless, and interestingly, this provision is situated in Title 4 of that charter, and which carries the title Solidarity, which is already pointing to the so far forgotten social element of sustainable development in EU policies. But of course, on the other hand, it's not an individual right, it's something like a principle. Article 37 would not qualify to rely on it in courts. So that is the downside of Article 37. So why am I trying to find kind of a legal contextualization to a wonderful governmental program? Because I basically think that even those huge bureaucratic processes would need, in a way, that somebody puts the legitimacy question, which is an inherent legal question. We need lawyers and we need the law to attribute rights and responsibilities, because this is a simple political program. We need, I think, the law to give orientation and to achieve coherence. And some of those functions, I think that we could do more as legal academics and practicing lawyers and, of course, judges, to more unfold and to reach the full potential of principles like the principle of sustainable development. As I stated, so far, judges, lawyers, and legal academics have already achieved something. We have, in a way, manifested the legal validity of the principle of sustainable development, as I explained. And we have been busy with developing some more important procedural dimensions, which is transparency, the idea that we should have impact assessments, and also we have been quite busy with giving a voice to individuals and to the civil society or to groups. We had a number of legal developments, both nationally, at a regional level, and internationally, in view of access to justice, in view of the involvement of civil society, and which, as you all know, basically resulted even in this fascinating area of climate action and environmental litigation. But what I think is so far left on the table and could be good PhD projects, so to speak, is first of all, and Dinah's talk reminded me to that we try to see all the Rio principles in context. So far we are picking out, be it sustainable development, be it the principle 15, which is precaution, or be it other principles. But especially the presentation of Dinah reminded me to saying that there's much more in the Rio Declaration, and that we should work on the question whether all those principles, how they fit together, and whether perhaps the Sustainable Development Principles is something like the umbrella for all of that, would help us to develop a more nuanced and more contextualized picture of all the interrelationship between the principles, which could help us in cases. Could it be in court cases, in legislation, or whatever you have? The second is, and there Latin America is, or Pan America, so to speak, is of course a forerunner, is to see the contexts between Sustainable Development Goals and human or fundamental rights, and vice versa. The kind of bringing into context Sustainable Development Goals with fundamental or human rights will help to add legitimacy to the Sustainable Development Goals and make them in a way also more tenable to courts and others who apply the law, if we have an understanding how the Sustainable Development Goals would be linked to certain individual rights, or the other way around, if we do interpret human rights or fundamental rights, then that we take recourse also to the Sustainable Development Goals to give us an orientation about the interpretation. So I think there could be much more be done in these two areas. But then on top of it, and then that is why I was fascinated by all the presentations in the panel on developing further other principles, was to see whether we could use the Sustainable Development Principle also to develop measures or criteria for coherence, for instance, of government policies. So for instance, in institutional and procedural dimensions, the question could be, is sustainable development from a legal point of view adequately reflected in the institutional setup? And if you look from this side, you would find, for instance, that in the European Union, sustainable development was for a long time separated between different directors generals of the Commission, and that until now we do not have a committee for sustainable development in the European Parliament. We have rather industry, social affairs, environmental affairs, trade affairs, and something like this. And of course, the European Parliament is very busy in giving its views on sustainability development. But wouldn't the principle perhaps require us to have one institutional core where all those facets and dimensions of sustainable development come together? And then secondly, I think we could do a good job in bringing coherence to the question whether governmental policies and legislation is based on proper assessment, discussed with proper participation, and has a review mechanism, because we understand that environmental affairs are developing all the time. And also, and thank you for others to point to those two principles, I would say that we could also do something in bringing coherence in applying the principle of proportionality, more enlightening than we do it before, and also perhaps the principle of non-discrimination, because funnily enough, if you read the constitutional law of the European Union, there's more than one. Indeed, there are many provisions which call for the coherence of European Union policies, and would be interesting to use this in context with the principle of sustainable development? I'm very sorry that I couldn't give you any answers, but I thought perhaps it's nice to give you some questions and some ideas to continue working for sustainable development. And thank you very much for your attention. Thank you.
Muchas gracias a ti, Peter.
Thank you very much, Peter, for that very interesting presentation.
Muy desafiante de cara a los problemas, ¿cierto? A los conflictos socioambientales.
And particularly these references to the conflicts and the issues that we are grappling with and that you're looking at in the EU. Panelists, given the time, since we have run rather late, we will not have an opportunity for a Q&A session, despite the high quality questions that were posed by the audience. Therefore, all I can do at this juncture is thank you for your remarks and for your participation. And therefore, I will give the floor back to our host, to Magdalena, as our moderator, our leader. Thank you very much, Mauricio. We again appreciate the participation of all. We will take a break. We are going to come back punctually at 3:20 p.m. Chile time to continue with our next and sixth and final session on judicial experiences. 3:20 p.m. Chile time, we will resume. That is in
Buenas tardes, buenas noches también donde corresponda. Bienvenidas y bienvenidos a esta última parte del cuarto Foro Internacional.
Good afternoon, good day, wherever you are. Welcome to this 4th International Environmental Justice. And we would begin right away with the 6th part of our panel, Judicial Experiences. And we will begin with Brian Preston, Chief Judge of the Land and Environment Court of New South Wales. Mr. Rafael Fernández Valverde, he is Magistrate of the Supreme Court of Spain, President of the section dedicated to urbanism and environment of the Administrative Litigation Chamber. Ms. Mary Kay Lynch, Environmental Appeals Board Judge at U.S. Environmental Protection Agency, and Mr. Rees from the Second Environmental Court in Chile. The moderator for this panel is Mr. Cristian del Pena, Chief Judge of the Second Environmental Court. Good afternoon, everybody. I would like to first welcome and thank the presence your presence here in this last panel. And for us, it is a very relevant panel as it allows us to receive lots of information from other courts that have to deal with environmental aspects. This panel then for us becomes a very relevant panel. In the context that we are going through right now, these are very brief words that I would like to present now. The environmental courts in Chile are in our 8th year of work. We are still in a very young environmental justice system, meaning that we somehow consider the need of permanently looking for ways to establish more maturity in the environmental aspect, especially in terms of protection of the environment, in the application of concepts and application of standards and principles. It is in this context that we can mention that Principle 10 of Rio Declaration, that among others is considering access to environmental justice, does not restrict this environmental justice to any type of court or specialized system. It opens the door to any system. It allows all states to determine how access to environmental justice will be working. Some can do it through administrative works, others maybe in special courts, others in ordinary justice, or as in Chile, they have decided to do it through specialized justice systems. Nonetheless, environmental problems that could exist are in practical terms the same problems, or maybe variations according to internal legislation, but concepts and environmental principles are all quite similar. In this opportunity, a part of wanting to be able to make important use of all the other courts and activities, we have also wanted to take the opportunity that after I just mentioned 7 years, we're almost 8 years in this activity, to present our own experience, our own short experience of these past 8 years, and to make it available to the critical analysis of the society. We understand that criticism is what allows us to grow and mature. It is in this context that this panel is considering judicial experiences, where we have 4 tremendous panelists with the Chief Judge, Magistrate of Spain, Mr. Rafael Fernández Valverde, our Honorable Judge of the Environmental Appeals Board, Mary Kay Lynch, and we will also have a video that was sent previously, given the time frame. The Chief Judge of the Land and Environment Court of New South Wales, Mr. Brian Preston, he is going to try to connect to this transmission, but in Australia it's 5 a.m. right now, so we cannot really ask him to be connected right now. So he was kind enough to send us a video that we will be showing. And I had the opportunity to see it at some point, and it is a wonderful presentation, a brilliant presentation that I really liked on a personal basis. Then we will have a Q&A round, and we also had the Chief Judge, Mr. Munoz, but unfortunately this morning he mentioned that he had a personal problem, therefore it will be impossible for him to participate. He apologized to the participants of the panel as well as the speakers, and he also sent his kind regards. We will now then go to the first presentation, that is Mr. Rafael Fernandez Valverde, whom I will be introducing right now. He holds a title in law from Sevilla University. He nowadays is president of he is the former president of the area of Linares. He works and is magistrate of the National Assembly, and he is magistrate of the Supreme Court of Spain. We want to thank you for being here today, and you have 20 minutes to present. Okay, thank you, Christian. It is important to be able to participate in this very important event from a perspective that is so specific, and that is the judicial perspective. I always have an idea that judges are always talking, so strategically speaking, this panel is very well placed. I would like to especially thank Cristian Del Piano for the invitation. And the truth is that we will be able to hold another Congress, a live Congress. And of course, this is a technique and communications, and be able to be 7 continents connected all together at the same time is wonderful. But this is something that I think it's important in this area. Of course, my greetings to Honorable Judge Alejandro Ruiz, and how he was very kind with me when I had the pleasure to visit his country in the second forum in Chile. I think this is a pioneering institution where it considers the area of law, environmental law in this case, together with some technical aspects that are adding to that possibility of trying to consider this legal and technical perspective in solving the environmental issues. As we heard, law is not enough to satisfy the different interests that could be happening right now. I am almost to retire, but I have had the feeling that there was an overflow of environmental justice somehow. This environmental justice is where the scope of activity is tremendously wide. And I always remember a very important mention, and now we hear that the landscape is how to look at each of the moments of history. These are not the only physical, material, and other aspects, but environmental justice is leaving that physical aspects, and it transfers to more intensive views of the world. And I had that feeling of overflowing, as I expressed earlier, of extrapolation to other areas of the law. And I did understand that we were seeing a lab when we talk about environmental justice, when we talk about urbanism. We are seeing a lab that at the beginning of the century, where we are reviewing and considering new perspectives and the different concepts, traditional, classic, and essential, or even mythical ideas of the administrative acts of the regulation. These are all basic elements that have supported this type of law, which is just wanting to consider the administrative jurisdiction. I thought that these were essential elements, and when working in the area of environmental justice, I have seen these new concepts. It is a view of the law that has always been supporting us and everybody that is involved in this area. Right now, I would like to highlight the capacity that environmental justice has had to be able to increase the concept of legitimacy at traditional level. You all know how much there have been advances in the Escazú Agreement, for example, or with the previous European environment. So the conclusion that I am able to reach is that we are breaking different concepts. You have talked about something that is quite normal in certain American constitutions, such as the legal personification of certain entities, just to call them somehow, not only the physical person, but the legal person. Along these presentations, we have been talking about the personification of the land, of rivers, or even an estuary in New Zealand, and the participation of one of the speakers. And I'd like to insist that we are here in a type of law that is working and it is under process, where we had one essential element in the area of all of these ideas, which is climate change. We are trying, obviously, to consider all of the principles of Paris. We had certain frustrations, and Honorable Justice Del Piano realized how the international conventions could not be held, but we did what we could to be able to help Chile in these very important aspects, and we ended up holding the convention that somehow started with a feeling of not feeling that comfortable in environmental law. There was a certain critical political position that was quite critical, maybe some coming from the US or China, just mentioning some of the more emblematic countries, as it made not what I would call a depression really, but it was sort of paralyzing these activities, or even taking us toward a demoralization of, for those that thought that environmental justice needed an international projection. We were doing all this. We were with Escazú, with all of the different comments, and we all of a sudden received COVID-19. We saw that it came into our lives, our worlds, and of course, there was at the first minute paralyzation in the real world and the social and the civil society, and we perceived that the law started working and environmental justice started to work even earlier than the rest of the legal activities. So I had prepared a completely different presentation than the one that I'm going to present right now, because I will just be presenting certain thoughts. And right now, I have the feeling that this situation surprised us all. We realized that we had to change, we had to evolve, that we were forced to doing this, and the situation from this perspective would be very important. And I just realized with the presentations that we are seeing along these days, and what you have been able to highlight is that the environmental activity has other mechanisms for the future, and it is the connection to the right to health. It seems to me that this is the main thought, is one of the main ideas that, from my perspective, are considering in these areas. I think environmental justice needed a subjective element that would graphically put together the person, the most intimate elements of people, such as health, for its projection in the world, as we all know. And the conditions are saying so. You can see how Article 45 of the Constitution is talking about the proper life, reasonable life, and of course, to have health and as considered in the Constitution. Each one in the different panels has participated from his own perspective, and everybody has been showing an important concern. It has expressed different essential elements in the framework of the different areas of their professional activity. They are what they're considering, but I would like to consider that essential idea of really being able to use all this push, this progress that is moving around environmental justice to try to establish some type of projection of what human health would be in the this mutual activities. And we are enjoying the proper environment for the development of the person, and we do have the possibility to carry it out. It is evident, though, that the connection between environment and health is a new pair, a new activity that allows it to say that environmental justice now has support, a basis that is far more objective. And this is what right now, as a magistrate, I am interested in, as this panel is really expressing the different judicial experiences. I would like to express three specific aspects where I feel that are new elements that we need to solve at jurisdictional level. One would be the constitutional element. In second place, it would be an element of accountability, a legal aspect. And then a third element, which is a very specific element that is already on a day-to-day basis, considering legal resolutions in different environments. I am talking about the idea of receiving or not the vaccine, for example. In Spain, it has happened that this is from a perspective from the Constitution, as before Mr. Professor Hager from Barcelona was saying, where the exceptional right does not help in consider situations such as these ones.
But there are situations that could occur, as we've seen in other aspects in environmental law at the international level. The disillusion, this disappointment, or we've seen a number of different Euro rulings that have fall into that category, but because they certainly don't meet the needs of a healthcare crisis. And so one conclusion is that from the constitutional perspective, and you in Chile have a magnificent opportunity now to take into consideration these thoughts, and that of the need to have health being at the constitutional level or constitutional rank. Of course, we need specific rules and regulations to grapple with individual issues, but we need, or what seems to be lacking, is something that affects fundamental rights. For example, the lockdown that we're experiencing in Spain and other countries, the possibility of limiting people's movement, and or the issue of, for example, of health procedures such as applying a vaccine. So one thing that I think we need to do from the legal perspective is to analyze these options. Now, what is happening in Spain, and it is happening today in Spain, is that we're seeing significant changes. The legislature and the executive branch have seen these needs, and they've tried to resolve this by taking certain measures and submitting the powers of the executive to the review of the judiciary. Now, of course, as judges, we are not refusing to do so, but what it seems is that acting in this fashion is questionable in terms of having us take ex ante action rather than ex post. There's something that is said, politicians say, get a judge in your life and you will have a happy government. But that's not the case. It's the executive that should have the ability to react, and it will be the judiciary that, as usual, picks up the pieces. But it is important, again, to have a constitutional level approach to deal with fundamental rights of individuals, such as the current situation that we are confronting, and other similar ones, whether it is the environment or healthcare. This needs to be ensured. A second issue that has been of concern, and where we've seen a case that we've seen in recent rulings, is who is liable. Are we talking about political liability, criminal liability? We're talking more about who is liable in economic terms. Let's say, I hope that we certainly don't see that these vaccines, for example, appear to be ineffective. God willing, that won't happen, but who is liable? How will they be held responsible if that does come to be the case? So the control over pharmaceutical companies that are subject to an excessive economic pressure by the governments regionally and internationally can lead to some undesirable effects. But of course, we need to be paying close attention to those types of situations. With that, I understand that the courts of law in our country are empowered, at least in Spain, to take action. And that is why the experience from the environmental court in Chile is so interesting, when you look at some of these issues. And a third point to wrap up has to do with a situation that is currently really complex. It's not easy to resolve. Of course, there is a constitutional underpinning, but it's also a personal issue. In Spain, there is a sense of indebtedness because we know that most of the deaths have occurred here in homes for our senior citizens. And then we get the question of the vaccines. We have a senior citizen, a 90-year-old. Should they receive these vaccines first? Are they in a cognitive position to agree to such an action? These are questions of prioritization and the sort of hedonistic policies to a certain extent. There have been some political approaches and policy approaches that have led to questioning the efficacy of these actions, but we are talking about individuals where group action is of the utmost importance. So those are some of the thoughts that I wanted to share with you. We are in a situation where we have tremendous possibilities and projections, but these are based on the material aspects more than anything else. If we're talking about history, but let us think about this seminar and understand that human beings have to interact with their environment and live in our own environment. So when we look at this concretely from the legal perspective and more specifically from the judicial perspective, we can look to see how we can implement environmental law to the benefit of all. Thank you very much, and I am certainly open to any of your questions. Thank you. Thank you, Rafael, for your presentation and also for sticking to time, 19 minutes.
Wow.
And it really was quite inspiring. Very interesting, the relationship between the law, the environment. These are certainly things that are going to see in the future. The question is, can we force people to receive a vaccine or not? That is certainly a valid question. I look forward to hearing people's answers. Let us now turn to our second panelist. Someone who comes from Chile. I mentioned this at the beginning, part of the extension of this panel, and the intent is that we should not only learn from the experience of other judges, but also to have an opportunity to share our own experience over these last few years. Toward that end, we've asked Alejandro Ruiz to join us. Justice Ruiz was a graduate of Catholic University in law and also Southwest Australia. He has advanced degrees in solid resources and others from the University of Chile. He has served in a variety of environmental positions, including at the Superintendency of the Environment Compliance Office, as well as serving as a justice and previously as Chief Justice of the Second Environmental Court of Santiago. So just before I give him the floor, let me remind you that you can pose your questions by chat on the website of the event, and we will summarize these questions and pose them to our speakers at the end of the event. Alejandro, you have 20 minutes.
Muchas gracias, Cristian, y muy buenas tardes a toda la audiencia. Voy a compartir una presentación que tengo. Ahí está, bueno. Quiero partir saludando a los ponentes e invitados a nuestra cuarta versión del Foro Internacional de Justicia Ambiental. Este es un evento muy especial que se ha ido consolidando en el concierto global y que, bueno, fue organizado en sus primeras versiones por los ahora exministros José Ignacio Vázquez y Rafael Asenjo. Por lo tanto, este es un trabajo que viene de bastante tiempo y que nos antecede a Cristian y a mí, y a Daniela, que ahora nos acompaña también. Bueno, como dijo nuestro presidente Cristian del Piano, es primera vez que lo estamos haciendo de forma virtual y esperamos sinceramente que esté cumpliendo con sus expectativas. En este panel originalmente estaba contemplado que presentara la jueza de la Corte de Suecia, Anna Tiber, pero ella debió excusarse hace unos días, así que Cristian gentilmente me pidió que si yo podía cubrir esa ausencia notable, veremos si estoy a la altura. Pero uno siempre está listo para contar de la experiencia chilena en materia de justicia ambiental y vaya que hay que contar y muy interesante de lo que ha ocurrido durante estos años. Bueno, la presentación que quiero compartir con ustedes...
So the presentation I'd like to share with you, these 20 minutes, is divided into three parts. First is the general aspects of environmental courts. The second is about the way we've addressed different aspects underlying our cases. And the third has to do with the challenges. It's basically one large challenge that we've had these years.
Bueno, como contexto, con motivo de la reforma a la institucionalidad ambiental que se acordó en el Senado en el año 2009 y que más tarde se
In 2009, the Senate agreed on this and it became a law a couple of years later. There was an environmental institution created, the environmental courts were created, and in 2013 they began to operate in Santiago, Valdivia, and later in 2017 in Antofagasta. So a new institutional structure was created in Chile. It's been very difficult to fully implement it, and today, 10 years after its creation, it is still not completed. Due to the lack of certain services, for example, of biodiversity and protected areas. That's what we need the most. We need to manage protected areas, endangered species, and other parts of Chile in order to fully implement it. These are the three courts we have. Chile is divided into three macro zones: north, Arica and Parinacota to Coquimbo; the center, Santiago to El Maule, going through Valparaíso; and the third is the south from Ñuble, going all the way down to Antarctica. Each of these have their own scope of action. They have different activities. We have a very diverse geographic territory. We could divide it into maybe industrial, real estate, mining, and water and other, but it is much more than that. I also don't want to have any arguments with my colleagues. In general terms, every environmental court has 5 ministers. 3 are the main judges and 2 are substitutes. We have ministers or honorable justices that are attorneys, and others have studied science. So this is a mixed commission, and it not only guarantees a multidisciplinary approach, but it also allows addressing the sciences. That's the most innovative thing that makes up our courts. So the competencies allocated to environmental courts are related to administrative actions that review the actions of the state in environmental aspects, including permits, sanctions, and then you have lawsuits for reparation in view of environmental damage, and this excludes the damage. We have the authorization and consultations as well. In terms of statistics, from the moment it was created in 2013 until the end of 2020, the Santiago environmental courts have seen 328 cases between claims and lawsuits. And in Antofagasta, as I mentioned, it began operating in 2017. The number is 48 cases. And in Valdivia, the environmental court in Valdivia has had 187 cases between claims and lawsuits. So who goes to these courts claiming some sort of illegal action? Most of them are claimants with an environmental interest, and I'd like to end with the large number of active stakeholders, municipalities, original peoples, individuals, and 43% of the claimants are companies that develop projects. And most of the lawsuits are made by the community or by municipalities or local governments, 27%, 37%, and the rest by the state and other companies. Here is the percentage of claims that have been accepted and which have been rejected. 49% of the claims presented or submitted to this court have been rejected, and 41% have been accepted, and 16% partially. Now, regarding the lawsuits for environmental damage, 56% have been rejected and 46% have been accepted and or been ruled admissible. And basically, in the past, many more were declared inadmissible. The effects are many, but today there is a legal community that is more knowledgeable of these processes. And as Professor Manuel Núñez said yesterday, when speaking of original peoples, the debate is much more sophisticated. Finally, as I mentioned in the third column, 70% of the cases taken to the Supreme Court have declared admissible only 30% of the cases. Now, to conclude this introduction, I must mention an important aspect here, which is the evaluation of the evidence, where the legislator separates from the traditional system. And the evidence is analyzed according to legal reasons, logical, scientific, technical, or experience. And these will be used to allocate a specific value to the evidence, or maybe they are dismissed. This is important for environmental judges. It's important to adequately motivate our divisions because they contain legal and scientific aspects. But we can't necessarily carry out papers for all these judgments. The second part I mentioned has to do with environmental risk and justice. It's been important to understand the risks. There are many risk situations that have been addressed, but always within legal frameworks. Defining a risk is complex. It always has been. And the term risk mentions that it is an undesirable state of reality that could take place as a result of natural activities or human actions. And there's socio-natural events as well, which is a relationship between nature and society, the natural phenomena plus society, which generates risk situations. And this has been very evident in places where there's socio-environmental conflicts, especially when these are large-scale projects or industrial areas. As a result of the concept of industrial parks or industrial areas, they're quite relevant and have a different concept of risk. Here we're talking about environmental justice, not environmental justice as we see it in this forum. That would explain this dimension. Our legislation does not necessarily have this concept of environmental justice. That's why IVth, for example, has said that this is one of the fundamental aspects of Chilean law, a formative aspect. And the US EPA basically mentions the equitable distribution of environmental loads so that public policies, and especially territorial ones, can consider this symmetry where part of the population takes the burden of an industrial effect that benefits many. We saw this in 2010 with the environmental impact declarations that, as we know, include negative externalities and social benefits. Having said this, the questions that arise are, how do we address this judicialization of risk? How do we address socio-environmental conflicts? And in these cases, or cases with these characteristics, we've found an element that makes it difficult to understand this. There's a regulatory deficit in many ways, and especially in territorial aspects. The judges need to rule differently. There are alternatives like the precautionary measures. The organic law established an innovative procedure that goes beyond civil process. It is about guaranteeing the efficacy of the process, but it goes beyond that, and it lies with the full controversy. And we're going to take a look at a couple of cases. The first was obvious in after the spill, when the Tanque Mimosa vessel in Quintero had a spill, and there was an emergency, an environmental emergency, but the bay was cleaned and there was no permanent environmental damage. But analyzing the case, those of us who analyzed it saw that year to year, these spills would take place and that the problem was an environmental risk. And this company had only part of its facilities assessed, and we saw that there was no actual assessment of risk to this activity, to the discharge of hydrocarbons. So we included it in the sentence, in the ruling. We included a risk assessment, which generated a lot of debate, but we thought it was most adequate under those circumstances. A more recent case, which was the D50 case, the municipality of Olmué was sued for environmental damage, alleging that their wastewater treatment plant was being mismanaged, and the community sued. So since there wasn't any updated monitoring information, there was a need to manage this risk and ordering the carrying out of an independent environmental audit to be carried out by the municipality, carried out at the plant by a technical organization duly registered in the Superintendency of the Environment, the SIS. That is where they then proposed some corrective measures. And this refers to risks that had some other aspects. The R164 case was about instruments that were not that were to be searched for. It only allows developing dangerous activities or hazardous activities in Lampa and Tiltil. You have 5 minutes, Alejandro. And here, different industries were producing environmental effects around them, had not been evaluated. They had not evaluated the risk of the situation. And this means that the metropolitan park had not been adequately assessed. So we concluded that the permit was legal and it was in order, and that this was not the responsibility of the owner of the project, but it is an area where there are several industries. There wasn't a risk assessment of the territory where many different industries were located. So it was necessary then to carry out a full analysis using the concept of environmental justice assessed by the EPA to understand the need for mechanisms to address the problem of environmental justice in order to understand the burden of territorial planning. And I was of the opinion that we should organize some actions to request some actions and studies from the different municipalities. A more recent case, more well-known, is the case of the Prevention and Decontamination Plan of Quintero Puchuncaví, which has had several episodes of contamination and poisoning of people. The new plan had significant improvements, and our role in this was to make sure that they were complying with the law. But there was also a study of the effluence of the park in that area. There were 14 industries, many of which are either uncomfortable or hazardous. And there were some surrounding areas that were suffering from it. So this time it was not prevention, it was a unanimous or majority vote, actually, where they ordered the Ministry of the Environment to update the information of the BRAS, the recovery program for the environment and social, and to make sure that the regulating plan for Valparaíso would be subjected to an environmental assessment and taking into account the environmental justice dimension. Finally, moving on to the conclusions, the challenges. I don't want to refer to all the challenges. There's many, internal, external, and I'd like to refer to just one. And I can say this personally, the main challenge we've had has been in operating these 8 years, contrary to anything anyone may think is organic, it is the mere possibility of integration of the court. We have 3 main ministers and 2 substitutes, but some have never gone. The appointment process has a series of stages. It goes through different authorities, then it's sent to the Supreme Court, then the president takes the list of 5 people and it is proposed again to the Supreme Court. The complexity of this program has made it the same way in all 3 courts. Out of the 15 ministers, we only see 9 until very recently. The courts have had to work for 14 months with only 2 ministers, and even using all of the tools they have for integration, it was not possible to complete the hearings or to hold the hearings. If we consider all these appointments and the election of names, it's 106 days, and this does not consider the political negotiation process in the Senate. You can add 2 more months, and there's a series of other procedures, the swearing in, and all the other procedures can add 2 or 3 more months. So we can easily come to a 1-year vacancy for positions that last 2 to 3 years. This has all been socialized by the Supreme Court because together with the Public Management Office, it was mentioned that the procedure to assess the candidates is something that the judiciary is responsible for according to the Constitution. There is no reason to hold these processes to other similar ones. It's very difficult to have courts without the necessary or minimum number of judges. It becomes an Achilles heel. And basically, the environmental court ministers selection has even more stages than a Supreme Court. It's completely disproportionate. So there needs to be a legal modification for this. So the question arises as to how we can modify this, how we can change this. There's many alternatives. It all goes through a legal reform, the appointment system. For example, handing the contest and the candidates over to the judiciary through the Supreme Court, and the final candidate selection would be the responsibility of the President of the Republic, similar to Article 78 of the Constitution, and it would then go to the Court of Appeals if necessary. Having said this, it's always an honor, a privilege, and a huge responsibility to work at the environmental courts. And in fact, this always offers us some way to continue doing our work in an uninterrupted fashion. Thank you.
Thank you very much, Alejandro. Very interesting presentation. And yes, the legal aspect of all risks is what we have been doing in our work, as well as the topology of risk in matters of environmental impact. The concept of environmental material justice, and to see how we consider the precautionary measures in Tiltil and the structural and organic problems that are all related to the court that everybody knows about, but it is always good to consider them. We will now offer the floor, and I would like to welcome Judge Brian Preston, as it is very early in Australia. He has been kind enough to connect to the meeting. After this presentation, or this introduction, we will show his video. I will now then have Mary Kay Lynch. Mary Kay Lynch she works as a judge in the Environmental Appeals Board as judge, and is advisor at the EPA. Her work is very well known, and she has different awards. And she was director of the office OECA. Mary Kay, thank you very much for accepting this invitation.
Buenas tardes and gracias, and a special thank you to Chief Justice Christian Del Piano, and greetings to Alejandro Reis, who honored my court with a visit to Washington, D.C. in 2018. It seems like a long time ago. Greetings to the other judges and very distinguished participants in this critically important forum on environmental justice. Of course, I only wish I was there in Chile, and I want to take a moment to really applaud you for the very ambitious commitments your country has made to combat climate change. I think there's no doubt that you'll be making a very big difference in air quality and health. And I was also very interested and inspired this morning when Professor Alves spoke about the efforts to include gender parity in your Constitution. Of course, in my country, we've yet to pass the Equal Rights Amendment. So I was I was thinking that that actually underscored something else she said this morning, and something I think that's been clear over the last 2 days, and that is all good things do not flow from the global north. I've learned quite a bit these last 2 days. And then I need to also give a special thank you to the translators. I have no idea how you do what you do, but I very much admire your work. And I apologize presenting in English. So maybe next time I'll learn some Spanish. So as noted, I'm an administrative judge with the Environmental Protection Agency, or EPA's Environmental Appeals Board, which we refer to as the EAB. And I hear and decide appeals of environmental cases, including challenges to federally issued permits under all of our environmental statutes, and then also to federal enforcement actions that the EPA takes. And today I'd like to focus on my role and experience in providing access to justice, which I think is at the heart of environmental justice. And I think it will help to address climate change. And I'm hoping that my presentation can complement some of the access issues that Professor Henry Jimenez talked about this morning. And so what I'd like to do is first give you the larger context of EPA and the EAB, and then I'd like to focus on my particular experience in providing access to justice. So I do have a PowerPoint, but I'm not going to go over in detail all of the slides. They will be available. So I'm going to try to share my screen here. Let's see. All right, can you see that?
Yes, I can see that.
All right, great. So the first slide illustrates some of the structural points I want to make. The EAB, the tribunal I sit on, is a specialized administrative tribunal located within the United States Environmental Protection Agency. And as a matter of fact, EPA just celebrated its 50th anniversary. EPA was established on December 2nd, 1970 by President Nixon. And in fact, over the last 50 years since 1970, we've actually made a tremendous amount of progress. So for example, since 1970, air pollution has fallen more than 77%. And 92% of our community water systems meet all health-based standards. And I want to say that, point out that we've made this environmental progress at the same time our economy was growing really by leaps and bounds. So we think the two can go together. And in fact, what we've learned over the years is that environmental degradation is actually an impediment to economic growth. But of course, what we need to focus on, as many speakers at the conference have said, is sustainable development. And of course, we have a lot more work to do, and we face many challenges, not the least of which is the climate crisis, indeed pandemic, which I also think is an environmental justice issue. But I'd like to offer that I think that the court that I sit on, the EAB, has been an important part of the progress we've made in the United States in making environmental justice a reality, regardless of where you live in this country or your political or economic status. And I would add, regardless of your gender or other personal or inherent attributes. And the EAB itself was established by regulation almost 29 years ago in March of 1992. So we have almost 29 years of a body of environmental law that's available. And even though we sit within the EPA, we are an impartial body and we're independent of all other components of the agency. And we have rules that protect that impartiality and independence. And so, well, why were we established in 1992? And it really was because there was a growing volume of litigation over the EPA permits and enforcement actions. But also what the rule talks about is allowing for a broader range of input and perspective in administrative decision-making, and lending greater authority to EPA's decisions and the conduct of fair adjudications. And we have rules that govern, again, our structure and our procedures. So what is our structure? Well, we're currently composed of 3 environmental appeals judges, including myself, and we're all career senior executives appointed through a competitive process. And again, we are not political appointees. And we all have significant environmental law experience, and we make our decisions sitting in panels of 3, and by rule, our decisions must be made by a majority vote. And so what's our role? Well, essentially it's to hear appeals in administrative enforcement cases and permitting cases under almost all of the US major environmental statutes, including the Clean Air Act. So next, who can appeal to the EAB? I'm not going to read the slide, but essentially, or generally, it's almost any interested party can appeal to the EAB over a permit. And for enforcement matters, it's if you're the recipient of an enforcement matter. But if at the trial level, the EPA enforcement office is dissatisfied with the decision, they can appeal to us as well. And a point I want to make in terms of access is that you can be self-represented. You don't need an attorney to have your case before our board. And in fact, we have many self-represented parties that appear before us, and there are no filing fees. So the next slide just illustrates where we fit into our government, and we are part of the we're part of the executive branch. And then the next slide illustrates the different types of enforcement cases and where we fit in. Basically, there are 3 types: criminal, civil, and administrative. And again, we hear the administrative cases. And this slide just illustrates the structure. I have a trigger finger here. The structure of federal administrative enforcement at EPA, and it begins with a complaint that is filed by the EPA enforcement office. And then if the person wants to challenge that, they go to a trial before an administrative law judge. And then if either EPA or the party who is subject to the enforcement action is dissatisfied, they appeal to us. And then if you don't like our decision, then you go to the federal civil court. And then this is a structure of permit cases. It begins with the issuance of a permit either by an EPA regional office or a tribe or a state that's delegated the authority to issue federal permits on EPA's behalf. And I would just point out here that states, because of sovereignty issues, states cannot issue permits on tribal lands, but EPA can do so. Then this next slide talks about the purpose of having administrative review bodies like EAB and some of the benefits. And one I'll highlight is, you know, we're providing expertise in very technical or legally complex matters, and we're evaluating and managing scientific evidence. You're not going to necessarily get that in the federal courts in the United States because they're courts of general jurisdiction, very broad scope, and the judges are not necessarily steeped in environmental law. One of the other main attributes is that much faster results. So you're getting expedited environmental compliance and you're avoiding protracted court review. And for example, for the EAB, my court, we decide cases in a matter of months versus in some of the federal courts, I mean, it's years. And then again, I mentioned this before, it's more cost effective because there aren't any fees or counsel provided. And then, well, how has the EAB facilitated compliance with environmental laws? I won't repeat what was on the previous slide, although I think it would apply, but two things I want to highlight, and that is, I think we really make an effort to provide a meaningful chance for stakeholders to participate in the process, and we make the process transparent and public. Our hearings are open to the public, and our decisions are all made public. And the second point I want to emphasize is that we provide consistency and predictability. And well, what do I mean by this? Well, let me explain that we follow a system of precedence, and that is that the principles we apply in one case will also apply in later cases involving similar issues. And again, we have 29 years of case law. And our hearings, as I mentioned, are open to the public and our decisions are publicly available. So this reliance on precedent combined with the availability of our arguments and our decisions helps promote clarity and consistency in the application of the law, and it helps guide behavior. So this next slide just illustrates at least four of the key principles that my body follows. And I was asked once what I thought the most important attribute for a judge was, and personally, I felt that it was impartiality, just in terms of the judge herself. And then the next slide just shows some of the attributes of providing full and fair hearings. And I'm not going to go over those, but again, if you have questions, you can contact me at a later time and I can go in more detail about, and these provisions are all by rule. And the same is true on the next slide for our rules for enforcement decisions. But this slide I want to focus on, and it's near towards the end of my remarks, on public access. And I first want to talk about the public access we provide to tribes. And as we discussed earlier this morning, you know, US tribal members are 4 times more likely to develop COVID than the general population, and the death rate is particularly high among their elders. So it is a vulnerable population for a number of reasons. But my tribunal has a long history of providing a forum to tribes to challenge or express their views, particularly in cases involving permits or licenses that are on tribal lands or impact their land or interest. And under US laws, tribes have sovereign rights, and the US has special trust and consultation responsibilities. And in many cases, EPA issues the permits on tribal lands. And these are most of the cases that are appealed involving tribes that come before the board. And again, states, because of sovereign issues, states cannot issue permits on tribal lands. But an example of one of the cases we resolved involving tribes, and it was through our alternative dispute resolution process, was a complicated case involving 5 Clean Water Act permits that EPA issued to a private company for wastewater discharges from oil production facilities that were on, this private company was operating on the Wind River Indian Reservation in Wyoming. And the case involved 7 parties, including 2 tribes, the Northern Arapaho tribe and the Eastern Shoshone tribe. And the EAB rules specifically provide that tribes can participate in cases that in which EPA is issuing the permit, but they can participate in order to protect their sovereign rights and their interest in discharges of wastewater that may impact their land and resources. And then just this month, we received an appeal of an EPA permit issued under the Safe Drinking Water Act on the Aboriginal lands and within the boundaries of the Great Sioux Reservation of 1868. It's located in South Dakota. And the EPA permit was issued to a private uranium mining operation to allow underground injection of wastewater that the Oglala Sioux tribe alleges violates EPA regulations, treaty rights they have, and requirements under the National Historic Preservation Act, and the U.S. duty to consult with the tribes. And just last night, a consortium of other tribes, the Great Plains Tribal Water Alliance, filed an amicus brief, a friend of the court brief, supporting the Sioux tribe's appeal to us. And their brief focuses on the treaty rights. And I'm the lead judge on that case. And we don't yet have EPA's response to the appeal, but it looks to be a quite interesting case.
Okay, 5 minutos, Mary Kay.
All right, great. So then I just next want to focus on how we provide access and involve environmental justice communities. And the EPA definition of environmental justice is on EPA's website. And the portion I want to highlight is the statement that includes environmental justice involves equal access to the decision-making process to have a healthy environment in which to live, learn, and work. And that's what my court focuses on, of course. And then EPA is also guided by a 1994 executive order to federal agencies like EPA to address environmental justice in the work that the agency does. Now, an executive order is not actually a law, but it's a direction that federal agencies are required to follow. And in fact, my court has remanded or sent back a number of permit cases to EPA regional offices where the record before us did not support a finding that the region had reasonably considered the contested environmental justice issues in their permit decision-making process. But I want to point something out, and that is that the 1994 executive order, which directs federal agencies to make EPA environmental justice part of their mission, states that the federal agencies are to implement the executive order consistent with and to the extent permitted by existing law. And in part because of this emphasis on existing law, the executive order is considered more procedural than substantive. So in other words, the executive order does not actually dictate any particular outcome in a permit decision. But I will note on this point that the incoming administration has announced and published a comprehensive environmental justice plan that includes the creation of an environmental and climate justice division within the Department of Justice. And it includes an increased focus on enforcement at all levels of the federal government. And there may also be federal legislation that impacts the consideration of environmental justice and the issuance of environmental permits and enforcement. So I was thinking that in 2 years, when you have your next forum, there may be a lot more to say on this topic. And then I'll just briefly mention that on the state level, the state of New Jersey, where I'm from, passed landmark environmental justice legislation in August 2020, and it requires the state Environmental Protection Department to identify the state's overburdened communities and only grant or renew permits for covered facilities after determining that there is no disproportionate cumulative environmental impacts on those communities. So that is a substantive right. They can actually deny or withdraw permits. And then I'd also note, again, in August 2020, the Fourth Circuit Federal Court of Appeals issued a decision based on Virginia state law and a state permit, and they revoked a permit for a compressor station supporting the Atlantic Coast Pipeline because it failed to consider the district health impacts on the local, primarily Black community in which it would be located. So again, there's a lot of interesting developments in this area in the United States. And then lastly, I just want to, on this topic, mention on COVID-19 and access to justice. Our court we normally have our hearings in our courtroom, or in some cases with the tribe, we'll go to the reservation because of their resource issues. But we now have our hearings all using something called Teams. It's virtual, and we've passed a rule that allows for the electronic filing of documents and service of documents by email. And then next, moving on, just to talk about the results we think we've achieved. I think our results really attest to the value of specialized appellate adjudication in the environmental context, like our court and your court in Chile, because what you see here is that in most instances, our adjudication resolves the dispute. It resolves the matter. Only a very small percentage of our decisions are appealed further to federal court, only 8%. And out of those, less than 1% are overturned. So again, I think we're providing a faster, cheaper decision and redress, that is sustainable and provides more access. And then finally, I would just invite people to visit the board's website, where I hope you'll find useful links and resources. You'll find our decisions and our regulations, our citizen guide, and our practice manual. So heartfelt thank you to everyone.
Thank you very much, Mary Kay. Muchas gracias.
Thank you very much, Mary Kay. I really highlight the concept of independence and partiality that you've noted, and also noting that we are a bit subject
necesidad o a esta tendencia
to this trend to increasing access to justice and having administrative courts or other courts to focus on these types of things. The truth is that these ideas really suggest that we need to delve into greater depth on these topics. And I have a number of questions myself that I would like to pose to you during the Q&A. To wrap up this session of this panel, and although Mr. Preston has joined the panel and we thank him for rising very early to join us when he kindly accepted the invitation a while back, given the tremendous time difference with Chile. He was concerned about not being able to appear in person. We have a video which we are going to share at this time. And then, of course, following that presentation, Judge Preston will be available to answer any questions that may arise.
Welcome and thank you for accepting our invitation. Si podemos poner el video, por favor.
If we can please run the video.
It's with great pleasure that I present to the 4th International Forum on Environmental Justice, being hosted by the 2nd Environmental Court in Chile. The session in which I've been asked to speak is on judicial experiences, a broad topic. What I thought I would speak about is how courts, and particularly environmental courts, can respond to the challenges that face society and the environment at the time, but do so in a proactive way. The outline of my discussion of the experience of courts will be threefold. First, I'll say how courts respond to societal change. Secondly, I'll say how courts, in turn, drive societal change. With that general discussion, I'll look at the particular example of the Land Environment Court of New South Wales, of which I am the Chief Judge. We can start with this proposition, which we all agree, and that is courts are responsive institutions. So courts respond to matters that are brought before them. Courts rarely act sua motu, that is, on their own motion. There are some instances of courts, particularly in India, that do move on their own motion. But elsewhere, that is very rare. Courts await parties bringing matters to the court. Now, also, of course, courts do not have their own agenda, either for law or policy reform or for societal change. So how do courts respond to societal change? Well, there are changes in society and they can drive changes in the law. So put shortly, the societal change can influence court decisions. A former Chief Justice of Australia, the Honourable Robert French, put it this way: with legal change and social change, the question may often be asked, which comes first, the chicken or the egg? In a sense, societal change always comes first. The cases which come before the courts and place demands on existing principles are a reflection of things happening in wider society. The courts do not have an agenda for promoting social change. So how does societal change influence court decisions? Well, the influence of society's attitudes on judicial decision-making can be seen in what may be referred to as both easy cases and hard cases. Now, easy cases are where there is no dispute about what the law says or how it applies to a particular set of facts. Hard cases are where there is a dispute about what is the relevant law, or what relevant legislation means, or whether and how the relevant legislation applies to a particular set of facts. Now, Jeremy Waldron disputes that there is any bright line between easy cases and hard cases. Nevertheless, the concept of easy cases and hard cases is a useful one to explain the different ways in which societal change can influence court decisions. So let's start with easy cases. Now, in easy cases, courts simply apply obviously applicable legislation. They find that particular legislation, it's obviously applicable, and they understand what the legislation means. Now, all legislation is normative. That is, it fixes and directs the action that needs to be taken according to norms that are embodied in the legislation. In environmental legislation, the norms may reflect the environmental consciousness of society. Let us take climate legislation. The legislature responds to societal attitudes calling for governments to take action about climate change. And so when the climate legislation is passed, they reflect that environmental or climate consciousness of society. So when courts apply legislation, they are applying the norms of society that are reflected in the legislation. Let's come to hard cases. So in hard cases, where there is no existing legal rule that is immediately applicable, courts need to find and then interpret the legal rule to be applied. Now, there are different views as to how this is done. If you compare the jurists H.L.A. Hart and Ronald Dworkin, you'll see different attitudes. Hart suggests that judges do make law, and that is quite legitimate to do so, while Dworkin suggests that judges do not make law, but instead find the law. I won't go into the different jurisprudential differences in jurisprudence that each of these jurists put forward. But what is important is, no matter which way judges make decisions, whether it is the way in which Hart suggests or whether it's the way that Dworkin suggests, judges will take into account moral considerations in making the law, which is what Hart says, or in finding the law, which is what Dworkin says. Now, these moral considerations include society's attitudes, which includes their environmental consciousness. So we can see under either approach, whether you're making or finding the law, the judges do take into account considerations of justice, social policy, and moral standards. And the environmental consciousness of society can influence these considerations. Societal change places demands on the court's adjudicative function. Now, to discharge this responsibility, courts need to be proactive. They have to actively respond to societal change. This is necessary in order to discharge their role of either making or finding the law. So courts need to identify and take into account in their judicial decision-making contemporary considerations of justice, social policy, and moral standards. I say contemporary because considerations of justice, social policy, and moral standards will evolve and change over time. And the court's task is to find out what are the contemporary considerations at the time the court makes its decision. Now, I've been talking so far about how societal attitudes and change can influence judicial decision-making. I want to now consider the converse, that is, how courts' decisions can influence societal change. Now, the legal change that affected by the court's decisions can drive societal change. It does this by influencing societal's awareness and attitudes. Now, one example is in the area of climate change litigation. So the court's decisions in climate change litigation can raise or lower climate consciousness of society depending upon what is the particular decision. So cases that have been made, decisions such as made as in the Netherlands of the agenda litigation at both the first instance decision in the District Court in The Hague, to the Court of Appeal decision in The Hague, through to the Supreme Court of Netherlands decision, all have had an effect of not only raising climate consciousness in the Netherlands, but also insofar as other countries look to that those decisions raise the climate consciousness in other countries. So how does the judicial decisions do this? Well, they do it in the 4 ways in which the judiciary performs its role. The first role is that courts uphold and enforce the law. They do this through declaring and upholding whatever is the law of the country. And they also sanction and remedy any breaches of the law. And so when they're making their decisions and they publicize those decisions, that has the effect of raising the consciousness of society and the actors in society about the law. Secondly, an essential role of the judiciary is to uphold the rule of law. Now, in public law cases, courts can hold the executive branch of government to account, directing compliance with environmental and climate laws. Thirdly, more generally, courts can enhance democracy. Now, judicial review of administrative action or inaction can enhance democratic processes, including the rights of the public to participate, and also enhance the quality of public administration. It does this through compelling the executive branch of government to comply with the will of the legislature as expressed in the legislation. The court's decision also brings scrutiny to bear on the deficiencies of the law and its execution. The judicial remand brings matters to legislative and executive attention and forces them on their agendas. And fourthly, the court's decisions uphold norms. These are norms that are found in the laws, particularly the legislation. The court's decisions publicize and promote the norms in the laws. And the courts also, in their adjudicative task of making or finding the law in order to decide the case, can expound norms. In both ways, the courts uphold the norms. Now, the exercise of these judicial functions have a number of effects. Firstly, they change the behaviour, that's the future behaviour, as well as the attitudes of the parties to the litigation. But more generally, because the court's decisions are publicised, they raise awareness and can change the attitudes of actors in society. These include the government, the private sector, civil society, communities, and individuals. And more generally, because law is itself a form of social ordering, when the courts change the law through their adjudication, they change the patterns of social ordering. And insofar as the court has said what has been deficiencies in governance, then that can have an effect on changing governance, whether by the government itself or by the private sector. Let me now come to apply these general considerations to a particular court, and the court is the Land and Environment Court of New South Wales. Now, the court is an old court. It was the first specialised environmental superior court in the world, and it commenced operation in 1980. Over 4 decades, the court, through its decisions, has effected both types of change. Firstly, it has effected legal change by responding to the changing considerations of justice, social policy, and moral standards. But it also has influenced social change by its decisions. The court's decisions have developed aspects of justice, including substantive, procedural, distributive, recognition, reparative, and restorative justice. Let me just highlight the ways in which it has done this. Starting with substantive justice, the court has developed the substantive justice in 3 areas. Firstly, the principles of ecologically sustainable development, including the principle of sustainable use, the precautionary principle, intergenerational equity, intra-generational equity, conservation of biological diversity and ecological integrity, and internalisation of external environmental costs, including the polluter pays principle. Secondly, in the area of environmental impact assessment, and thirdly, in sentencing for environmental crime or environmental offences. Nextly, the court has developed procedural justice. The court has upheld access to information, public participation, and access to justice. This has been done in many ways, but one of the ways is by lowering barriers to public interest litigation, such as removing the rules or lowering the rules in relation to standing, undertakings for damages, for interlocutory injunctions, security for costs, late fees, and costs of proceedings. The court has also developed distributive justice. It has ensured the equitable distribution of the benefits and the burdens of development between people and groups by upholding intergenerational equity and intra-generational equity, applying the polluter pays principle, and balancing public and private rights and responsibilities. The court has developed recognition justice. It has recognised and given voice to marginalised and vulnerable individuals and groups, including Aboriginal people, by allowing access to the courts. The court has developed reparative justice. By crafting remedies for breach of planning or environmental laws, and in sentencing for environmental offences, the court has sought to repair the harm caused by a breach of the law or an offence, and has implemented the polluter pays principle. The court has developed restorative justice. The court, in sentencing for environmental offences, has directed the taking of restorative action for the benefit of the victims of the crime and the community affected by the commission of the offence. The restorative process can include a restorative justice conference or a victim offender mediation. Now, the court's decisions have also changed governance, but not only by the government itself, but also by the private sector. One example is in the principles of ecologically sustainable development. The court's decisions explicating and applying the principles of ESD have changed the assessment, approval, and implementation of activities that may impact the environment. A more particular example is of social impact assessment. The court's decisions on the assessment of the social impacts of activities have also changed the assessment, approval, and implementation of activities that impact on communities, groups, and individuals. Another example is in the area of climate change litigation. The court's decisions in climate litigation have influenced litigation not only in Australia, but also overseas. One example is the recent decision in Gloucester Resources. Now, the Gloucester decision, one professor said, is certainly getting attention outside of Australia. Climate litigation is emerging everywhere around the world, meaning that people have an interest in seeing what courts in other countries decide. Another professor from Belgium said, climate change cases tend to feed off each other. Where you see the law moving into areas that are in some respects new, it's not at all uncommon for both plaintiffs and judges alike to look across borders for examples of relevant precedents. Now, the Gloucester decision is being picked up around the world as well as in Australia. One example is litigation by youth plaintiffs supported by Our Children's Trust in the Supreme Court of Oregon. In an amicus brief filed in support of the youth plaintiffs, the authors referred to the court's decision in Gloucester concerning intergenerational inequity. In Canada, in a case Rainforest Conservation Foundation, the Attorney General of Canada, the youth plaintiffs challenging an approval for the Trans Mountain Pipeline expansion argued that there needed to be consideration of downstream emissions. And the plaintiffs referred to the reasoning in the Gloucester decision, rejecting the market substitution argument. And then close to home, in a recent decision in the Land Environment Court, a independent government agency had followed the decision in Gloucester to refuse a new coal mine, partly because of the climate change effects. The miner, who was disappointed by that decision, sought to judicially review the government's decision. That was recently held to be unsuccessful, and the court rejected it. So let me conclude. The famous jurist Oliver Wendell Holmes said, "The life of the law has not been logic, it has been experience. The felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, whether avowed or unconscious, even the prejudices which judges share with their fellow men, have had a good deal more to do than the syllogism in determining the rules by which men should be governed." So too, we can see that the life of courts dealing with environmental disputes has been experience, responding to an ever-changing society and environment. Thank you for your attention.
Muchas gracias, Brian, por su extraordinaria presentación.
Thank you very much, Brian, for your remarks, and we really appreciate how the courts are responding to social change and other, as well as the ability to influence social change. These two pillars of your presentation, Your Honor, have been very interesting and I think are core to our consideration, and the work that you have done is certainly an example of that in terms of the role of the courts in a society that is evolving, in a society that is increasingly fluid, liquid, as some would say. it's much harder in many cases to read societal preferences and norms. We'll turn to the Q&A session at this point. We have a number of questions. Let me start with Rafael. I have 3 questions for you.
I have 3 questions for you. I will present the 3 questions and you organize how to respond them. What would establish a difference between the right of life in terms of health of people and the right to life and the right to health and a healthy environment? The second question is how to overcome the anthropocentric view and to be concerned about life and health. Do you think it is important to overcome this anthropogenic view, or can we approach this issue from this view? And the third question is, which are the effects for environmental courts, the exceptional activities that you describe where the authority acts in emergency as extreme situations such as the ones in Spain that are relaxing the different activities in administrative areas? Well, they're tremendous questions, but I do not want to go too long. The first one, I have tried to establish a parallelism between health and environment. And now I am requested to increase this and to place the parallel between life and environment. I think logically there is a parallelism here. I would like to read our Article 45(2) of our Constitution that says that the public powers will consider the rational use of all natural resources so as to protect and improve quality of life and to defend and restore, etc., etc. So here is a constitutional mandate where the connection is established between the environment and life. Therefore, what I have tried doing here is to extract environment and health as part of life. I fully agree then with what is being expressed, and evidently enough what I am doing, as mentioned earlier, I consider this a subjective element to consider this environmental right that we're talking about. And of course, I maintain a contradictory position here with some of the considerations of these days, which is to overcome the anthropocentric concept of environmental justice. Of course, as a magistrate and being trained in a subjective perspective, and where the main references have all been the human rights declarations as well as all of the human declarations, I accept this advancement from a perspective that is more objective, as some very interesting comments have been already presented. But of course, this still needs to mature from the legal perspective. What I do not think is reasonable is to use the subjective concepts of the traditional character to transfer them to elements that do not consider the traditional activity of the legal entity from a strictly personal perspective to other types of entities. But there are very interesting advances, at least in our country. There is a very important activity in an area that is related to what we're talking about, and it is placed in a criminal law. Up to now, it was almost impossible to receive a ruling at criminal level if it was not a physical person. But this legal entity has considered that at criminal level, there can be a ruling to societies or others. And in other areas of the law, there is a widening in this sense. And of course, the what has been presented along these days is not similar to this, but we would need to move ahead in these legal areas with a parallel element that determines what has been currently acknowledged. And of course, emergency, which is the third issue that was asked. I think my colleague from Barcelona University has expressed that the exceptional right considered by all constitutions is an exceptional right that has been based in political crisis, of political activities, of rebellion of others, but it has not considered the constitutional perspective of supporting these activities that are extraordinary given emergencies, when this emergency is determined as what we're going through right now in this situation of a pandemic at world level. Therefore, in summarizing, I think that the right to life should be intimately connected to the environment. Second, I am not opposed to the evolution of leaving anthropocentrism, but there are some certain difficulties here. And of course, what I am placing on the table is that the Chilean constituents could do something very interesting, which is to establish an exceptional right for the public powers, but for non-political reasons, but rather environmental or sanitary. Thank you very much. For Alejandro, I have a couple of questions, and they're all pretty much focused in terms of risk. The first one is whether you consider that this is of a jurisdictional activity, and if the environmental courts can act when there's risk. And something more general, how do you consider risk if they are undesirable events for people or ecosystems, with the independency of people that are affected directly? And a third question or link to this is, which are the measures that the court is considering for risk? Is it enough to consider studies and analyze risk? And whether the integration of courts have meant important risks in this area. And finally, another question also linked to risk is, when we are considering an equal distribution of environmental burden, do these activities increase in lowering risk, which is the role of environmental courts? He is muted. The last question, I couldn't hear it. When we have an equal burden of environmental issues, whether the argumentation increases in managing risk, which would be, in this case, the role of the environmental courts. Thank you, Christian. Yes, they're all related questions. With regard to risk as the legal intervention, Article 24 of Law 20,600 establishes a very wide consideration that allows more flexibility than in civil cases to be able to participate in these environmental issues. This could be very easily taken to risk when, in our cases, we visualize that there is a situation of risk, especially if it is imminent risk, the same way that Article 48 and 3 of the Organic Law of the Environment Superintendency establishes that they can act through provisional measures or transient measures. And the same way, we can see this possibility, even though it is judicial with other characteristics, but also as precautionary measures. But it exists, and what we have been doing, and as a matter of fact, it has been validated by the Supreme Court. When I talk about risk in this environmental judicial area, I am not only talking about people, communities, but also ecosystems. Therefore, the environmental risk is inclusive to the ecosystem and the health of people, as Rafael is mentioning. But in terms of the measures that we have taken or that he have requested from the rest of the administration to adopt, they have varied, of course. And evidently, this requests previous studies of the specific areas of these organisms when in the case of hydrocarbon spill in an app in Quinteros Bay, there was a risk assessment for this company. Article 70 of letter G 19,300 law considers that the Ministry of the Environment has to have an action guideline for risk assessment. So they have the possibilities to work in this area. It is quite innovative. It generated some doubts and concerns, and there were some consultations in this area on behalf of the ministry, but we believe that it was interesting to do it like this. And likewise, when there have been precautionary measures established, we have studied the case of the Superintendency of the Environment. There were other organisms where they can, of course, deal with their area of work. Now, if the risk has had effects in our integration, when I say that the integration problems or replacement or however we want to call it in court has been a situation that is complicating good functioning, and I am talking about any type of action in the courts, and this is part of the cases that we are dealing with. I don't know if I responded everything. Thank you. I have a question for America. I have a number of questions for her as well as for Brian. Brian, are you hearing the interpretation, Brian? Are you hearing the English? Brian, can you hear us?
Yes, I can hear the translation very well. Thank you.
Voy a hacer una pregunta a Mary Kay.
I have a question for Mary Kay, and there are a couple of questions that are here for both of you, but I will consider to put them together for both of you because they are questions that, as moderator, I will consider that it's good for both of you to respond. They're very good questions. The first one for Mary Kay, the question that is asked to her directly is, which has been the role of women and feminist movements in environmental justice in the U.S.?
Well, it was the environmental justice movement in the United States actually began in the South, and it was started by a woman, community organizer. And so there's a long, full history in the United States. Women have definitely been at the forefront, and I was privileged to work in our regional office in Atlanta, and one of the people I worked with who ran our environmental justice program was actually the young woman who integrated when she was 18 years old, the University of Alabama. You know, you see these pictures of her walking to school with angry mobs and National Guards. And I once asked her, what, she was just the nicest person and showed no anger. And I asked her, and you had to see her in a community. I mean, she could bring people together. And I said, why aren't you angry? And she didn't even pause. She said, Mary Kay, I don't have time to be angry. It would interfere with the work I wanted to do. So the short answer is, and there's lots of names, I wouldn't want to leave anybody out, but there is a long tradition.
Thank you very much. Y tengo una segunda pregunta, perdón.
I have a second question. And I'd also like to know, well, you're an administrative court, so you're subject to a judicial review from a general civil justice court.
Yes.
How intense is that with respect to the rulings, the judgments that you adopt? Is there any difference, or is it just more intense in terms of the review? What is your experience?
Well, it's very intense, and in fact, one of my
Bastante intenso, la verdad es que, sorry.
it's very one of my cases is up for review, and there's an oral argument next week on the 21st of January, so I'm going to watch that. But they generally review our cases under the Administrative Procedures Act to make sure that our decision was supported on the record and it was not arbitrary and capricious. But the parties file extensive briefs in federal court. There's oral argument. But that one chart I had shows that we're overturned less than 1% of the time. And the First Circuit in one of their decisions discussed the thoroughness of the board's decision. And another Eighth Circuit out in Denver said that because of the thoroughness of our decisions, they were actually we were entitled to a level of deference. I mean, our review is on the record, and well, some people now, I'll be frank here, some people say our decisions are way too long. I mean, we have decisions that are 100 pages, but we're trying to make them appeal proof. I mean, if you read our decisions, we kind of weave together the narrative. We discuss the arguments both sides make, and we have very detailed references to the record, that's before us. So we try to make it easy for the reviewing court. Like I said, some people complain they're too long, and they may be right. I wouldn't argue with that, but.
Thank you very much. De las restantes, de las preguntas, quiero preguntarles
Of the remaining questions, I'd like to ask Brian, in terms of climate change litigation, what complexities have you seen when you deal with climate change? From the legislative point of view, normative, what complexities do you usually face in this sense? And the second question I would like to ask both of you is whether you promote, if you do, mediation or conciliations. And finally, a third question.
En materia probatoria, cuando tiene que realizarse pruebas en determinadas...
In probatory measures, when you need to offer evidence, where there's sanctions. One of the access barriers to environmental justice are the costs of gathering the evidence. How have you dealt with this? Have you been able to adopt any measures, for example, to obtain evidence or generate your own evidence? Or how have you been able to resolve this point? Mary Kay, perhaps you can answer, and then Brian.
Well, we don't take evidence because our review is on the record. And in fact, in a number of instances, a party will try to introduce new information or new evidence, and that's against the rules. So we review the evidence that's already in the record, because we're an appellate body. We're making sure that the decision below was sufficient. And then, what was the first question?
Sorry, las tengo. The climate change litigation. de la en materia de litigación climática.
Climate change litigation. How do you deal with climate change litigation beyond the rulings that you've had to make, or what barriers have you found?
Well, we're dealing with like the specific permits that are issued that could impact climate change, or the specific, so under the Clean Air Act, for example, or some of these oil production facilities, or in enforcement actions. So, and most of those statutes are strict liability. So on my court, we're not dealing with some of the more complicated issues that Justin Preston and others and Fernandez have to deal with.
Mr. Preston, thank you very much.
Okay, the first, the climate litigation one. They are complex, and the different arguments. There is the intersection of policy and law. There is questions as to whether the judiciary is trespassing into the province of the political arms of government, the executive and the legislature. So these issues arise, questions Americans refer to as the political question doctrine. But look, it doesn't, mostly it is resolved. It never stops our court intervening, but it does perhaps put constraints on the way in which we intervene. So I think if I have to say what are the issues that have arisen, mostly, especially in recent litigation, in the last 10 years or so, questions about, is climate change real? Is it causing impacts? Are humans responsible for it? Have all been resolved. That is not raised by government or by industry now. So we're really moving into a different types of issues, particularly issues as to what is the scope of the impacts that should be considered. I referred to one case about downstream impacts. So when you're looking at not only the emissions caused in, say, the extraction of fossil fuels, but also in the transportation to the ultimate users, or in the combustion of the fossil fuels by those users. They all cause emissions. To what extent do you take into account those emissions in deciding whether or not to approve a fossil fuel extraction project? That arises. Questions about causation, to what extent, insofar as there's going to be an impact, it's only a small impact in global terms, therefore is that to be taken into consideration? Arguments of market substitution or carbon leakage. So where if we don't do it, somebody else will, so why don't we do it here? That argument is regularly run and dealt with. So there's quite complex issues. They're both in science, insofar as the causation issue, law, trying to understand what legal test is to be applied, economics, insofar as the sort of market substitution arguments. So they are complex, polycentric problems. I think sometimes they refer to the climate law as a super wicked problem, and that certainly arises in our cases. In relation to mediation, the second question, yes, very important mediation. I'll put a little promo in now. The court just won the Innovator of the Year award in Australia for all, well, not only courts and tribunals, but also other legal institutions, because of our adaptiveness to the coronavirus pandemic in promoting ADR through remote technologies and video technology, Microsoft Teams, Zoom meetings, the type of thing. So we have always thought of ways in which we can do it, and that's a presentation, and I'm happy to share materials about our whole ADR program, but it's used in every area. The third question concerned evidence gathering, and you're quite right, Christian. This is a problem around for environmental courts and tribunals around the world. Especially, how do they get access to the evidence? We are fortunate that we are in a developed country, so basically the parties, particularly of course the proponents of activities and governments, do have access to financial sources to hire their own experts to adduce the evidence. We also have certain environmental legal aid centres who represent environmental NGOs, citizens and groups and communities, and they are able to provide assistance in securing expert evidence. So cases that come before the court normally have experts from all sides. But the court is a hybrid institution. We have both judges and expert commissioners, so similar to the Chilean system. So we have scientists, economists, hydrologists, planners, architects, engineers, the full gamut of disciplines that you need for environmental problems. And they are on the court as well. And that assists, because if you do have parties who are unable to hire their own experts, then at least the court can ask questions and look at the record to try and see what can be done. So there's a slight leveling of the playing field by having expert in the tribunal itself. Now, that doesn't mean to say that the commissioners, the expert commissioners, go out and gather evidence themselves. They don't. But they can ask the parties. They can direct questions. They can say what should be done. And in some instances, we also do direct the appointment of an expert, so a court-appointed expert. And normally we try to require the parties to pay for that. We on a sort of user pays basis, but we see who can best afford to pay for it. If one party is impoverished, they won't pay for it. But if one party is wealthy, which is normally the case for a developer, they will be able to pay for it. So the court then appoints an expert, which is paid for by that developer, but it is the expert is answerable to the court, not to the party who might pay for their commission. So there are a variety of ways in which we do gather evidence and have it before the court, and that's some of the ways.
Christian, could I go back to the second question for a moment? And,
yes, of course.
And just say that the board has a very successful mediation program. And in fact, one of the tribal cases I mentioned was resolved through our mediation program. There were 7 parties, 2 tribes. The parties were literally not speaking to each other. And the tribes, in fact, had very different interests. And after a lot of work, we actually, the parties reached an agreement where the 5 Clean Water Act permits were revised to everyone's satisfaction. And perhaps more importantly, the parties actually developed a relationship, and they kind of own now the resolution. you know, they're bought into it. They have a vested interest in it. So our experience is that the resolutions are longer lasting. So we strongly believe in mediation and have had great success with it. And information about our specific program is on our website. So.
Excelente. Bien, yo les agradezco a los
Thank you
expositores.
very much to the speakers.
Me dice Rafael si puede intervenir, quiere decir una...
Rafael would like to make a comment. Rafael? Yes, thank you. I thought it was very interesting. Well, the question that you asked was very interesting, and it is related to what we normally do. The relationship between administrative courts and the jurisdictional courts. My three colleagues all form part of administrative courts, and I congratulate you for the implications, but I have to speak from a more jurisdictional perspective. This is a very interesting debate, and it's not only in Spain, at a European level. In fact, a couple of years ago, in the European Parliament, there was a democratic deficit. There wasn't a direct election of parliament members. And here I'm speaking as vice president of the Council of the Judiciary. We no longer have a Supreme Tribunal. We have courts of justice and the International Court of Human Rights. But in the countries, we don't directly intervene in the appointment of these judges. This is a permanent and ongoing debate where Spain is being very successful in all these conflict resolution courts. We're having great success. We also have administrative tax courts and all these, and sports courts actually, and they all function very well. But in the jurisdictional court imposes itself on those as in terms of the authorizations and permits issuance. And I believe that with all three representatives that we see, the administrative court representatives that are so invested and have shown their personal and institutional perspective, I believe this is key for forming a positive relationship in our courts. Our courts are overworked, and this is very well. It is actually a more economic issue. I don't want to create a debate here, but it's the same thing with the judiciary councils. There's many elements that supplement each other, and as the Romans said, we should give to each his own. Thank you. Thank you very much. I would like to thank all our speakers, Mary Kay, Alejandro, Rafael, Brian, for your words. I'd like to offer the floor to Magdalena, and then we will proceed to closing the forum. Thank you, Magdalena. Thank you then to all our speakers during this panel for your very interesting presentations. So once again, we will offer the floor to the chair, Cristian del Piano, in order for him to say some closing statements. Thank you, Magdalena. I
would first like to thank the 24 speakers for their outstanding and world-class presentations. They are all world-class speakers, of course. There is much before us. We've learned tremendously, and of course, we'll need time to process this learning. I'd also like to thank the people that have participated in organizing this event. It has been held virtually because of current conditions, but it has required the commitment of a number of people who have been working hard behind the scenes. From the court, I would like to recognize Paulo Casanova, Carla Vega, and the justices. I don't want to leave anyone by the wayside, but all of the research and studies units that have been supporting us, I would like to thank them and congratulate them for bringing this to fruition. Priscilla, Roberto, Parada, the interpreters who have been with us over the course of the last 2 days, who have worked very hard. We have 2 major events at the court. One, of course, is our public rendition of accounts. After everything that Rafael has said, it'll be a tall task. But the second most solemn event that we have is this one, this forum on environmental law. As the Chief Justice, this is something that I have inherited from my predecessors, and I believe that it is our responsibility to bring it to fruition. We have managed to do so. We held the 3rd forum, now the 4th one, again virtually, because of the current contingencies and conditions. But this is something that we look forward to tremendously every 2 years. The forum will be posted as a link on our website, theenvironmentalcourt.cl, and the recording will be available subsequently of the entire thing. I look forward to 2022 or 2023, early 2023, to hopefully be able to meet in person for the 5th International Environmental Law Forum. And I look forward hopefully to seeing all of you in person and to not only enjoy our knowledge, but also each other's company over a delicious glass of Chilean wine. Thank you very much. On this note, we will conclude in this session and the 4th forum. We appreciate the exchange of knowledge and the tremendous interest of all of you who have connected via streaming. Thank you as well for joining us, and we look forward to seeing you on a future occasion. Thank you.
En el bicentenario de su existencia, el país se puso como meta fortalecer la institucionalidad ambiental a fin de propender un desarrollo sostenible para Chile. En 2012, con la publicación de la Ley 20.600, nacen los tribunales ambientales, órganos autónomos, especializados y de composición mixta, creados para conocer y resolver las disputas que les hagan llegar personas naturales o jurídicas que estimen que se han infringido disposiciones legales a través de actos ambientales del Estado o hayan sufrido daño o perjuicio en materia medioambiental.